ಒಂದು ಮಂಡ್ಯಗೆ ಆಜ್ಞೆ ಕೊಟ್ಟು ಎಲ್ಲ ಇಲ್ಲೇ ಅದಾವ ಅವರು ಯಾರು ಇಲ್ಲ. ಮಂಗಳವಾರ ಔಷಧ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಶ್ರೀರಾಮ್ ಸರ್. ಶ್ರೀರಾಮ್ ಸರ್
ಮೇಡಮ್
ಇದು ಮೆಮೊ ನನಗೀಗ ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂತೀನಿ, ಒಂದ್ ಸ್ವಲ್ಪ ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡ್ತೀನಿ.
ಹಾ
ಅಡ್ಜರ್ಮೆಂಟಿಗೆ
ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀವಿ ಮೇಡಮ್, ಪೇಜ್ ವೈಸ್ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ ಮಾಡ್ರಿ, ಬಟ್ ಆಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೋರಿ. ನಾನು ಹ್ಯಾಂಡ್ ರೈಸ್ ಮಾಡ್ತೇನೆ ಈಗ ಇನ್ನೊಂದ್ 5 ನಿಮಿಷಕ್ಕೆ ಸರ್ ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ.
ಆಲ್ರೆಡಿ ಒಳಗಡೆನೆ ಇದ್ದೀರಾ ಈಗ? ಆಲ್ರೆಡಿ ಒಳಗಡೆ
ಸರಿ 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 ಸರಿ.
ಫೈನ್ ಇಲ್ಲ, ಫೈ ಯಾರಿಗೂ ಹೋಯ್ತು ಗೊತ್ತಿಲ್ಲ. ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಒಂದು ಮಿನಿಟ್ ಕೇಳ್ತಿದ್ದಾರೆ ಮೈಸೂರು ಫೋನ್ ಮಾಡಿ. ಏನ್ ನೋಡ್ರಿ ಹಲೋ, ಟೋಟಲ್ 5 ಯಾರಿಗೆ ಹೋಗಿದೆ? ರವಿವಸ್ಮನ್ ಸಾಹೇಬ್ರು ಹೋಗಿದೆ ಅಂತ ನೋಡಿ. ರವಿವಸ್ಮನ್ ಸಾಹೇಬ್ರು ಹೋಗಿದೆ 5 ಎಲ್ಲ ರವಿವಸ್ಮನ್ ಸಾಹೇಬ್ರು ಹೋಗಿದೆ ಸರ್. ಟೋಟಲ್ 5 ರವಿವಸ್ಮನ್ ಸಾಹೇಬ್ರಿಗೆ ಹೋಗಿದೆ. ಟೋಟಲ್ 5 ರವಿವಸ್ಮನ್ ಸಾಹೇಬ್ ಕೋಟಾಲ್ಗೆ ಹೋಗಿದೆ ಎಲ್ಲ. 6 ನಮಗೆ ಬಂದಿದೆ, 6 ಇಲ್ಲಿದೆ, 5 ಅಲ್ಲಿ ಹೋಗಿದೆ.
ಫೈದು 9 ಹೋಗೈತಾ?
5 8 5 8
6 ತಗೊಳ್ತಾರೆ ಇಷ್ಟಿಗೆ.
ನೀವು ಹೇಳ್ಬಿಡ್ರಿ ಅವಂಗ ಹುಷಾರ ಒಂದು ಇಸ್ಕೊಂತೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಹೇಳಿ ಸರ್.
ಫಸ್ಟ್ ಮ್ಯಾಟರು ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಆಫ್ ಆರ್ಡರ್.
ಹಾ
ನಾನು ಆಗ್ಲೇ ಲಾಗಿನ್ ಆಗಿದ್ದೀನಿ.
ಆಯ್ತು ಸರ್, ಆಯ್ತು. ಅನೌನ್ಸ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
ಟೋಟಲ್ ಮಾಡಿದ್ನಲ್ಲ
ಹನ್ನೊಂದಿದೆ, ಅವನ ಹತ್ತಂತ ಬಂದಿದೆ.
ಟೋಟಲ್ 4 ಇದೆ.
ಬೆಂಗಳೂರು 230 ಮಾಡ್ತಾರೆ, ಧಾರವಾಡ 230 ಮಾಡಲ್ಲ. ಕಟ್ ಆಯ್ತು ಸರ್, ಚೇಂಜ್ ಮಾಡಿ ಚೇಂಜ್ ಮಾಡಿ ಈ ಟೇಬಲ್
ಯಾರಿಗೂ ಸ್ಯಾಟರ್ಡೇ ಇಲ್ವಾ?
The urgency is your lordship. Without making me a party, they are offering an order from this honorable court. And they are trying to get out the court, Nala in my feed your lordships.
But it's a pending matter.
No, this is I have filed a
Fresh matter.
They have already taken separate action.
How can you move it in a separate matter? It has to be moved in that matter.
That matter is already
Disposed.
That's one.
One ನಿಮಿಷ. 230.
She has been deleted in the provisional list. She has been qualified, my lords, in the final list.
ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Opponent, my lords, Jilla Panchayat Koppal.
ಸರ್ವ್ ಮಾಡಿ.
Yes, yes.
ಕಾಪಿ ಸರ್ವಿಸ್ ಮಾಡಿ ಸರ್, ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವಿಸ್ ಮಾಡಿ.
ಹಾ ಹೇಳಿ.
The amendment of plaint malad has been rejected. Only
Ashte
typographical mistake on Monday malad.
ಟ್ಯೂಸ್ಡೇ.
One GM police.
ಒಂದ್ ನಿಮಿಷ ಇರ್ರಿ, ಮತ್ತೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೆಂಟ್ ಮಧ್ಯದಲ್ಲಿ.
One matter for 230, my lordship.
ಏನಂತ ಹೇಳಿ.
Even though there is an injunction order from the court, my lordship, some persons are obstructing and they are put up constructions, my lordship, in the suit property. There is an injunction order from the trial court, my
What do
lordship.
you have to do?
There is a decree, my lordship, but I have given representation to the authorities. They are not.
Representation ಅಂತ ಆಗುತ್ತೆ ಅಷ್ಟೇ. We can't do anything in that.
Can let 230, my lordship.
230 ಮತ್ತೆ ರಿಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕು.
Please.
One GM police, notes where the suit is decreed, final decree is also came to my lord. Notes mutation entries, now the adjoining owners, notes brothers are obstructing. I made a complaint, they are only issuing the endorsement, it amounts to LPT. Now I am notes, even I have made.
TP is pending.
Pending, disposed of, FDP is also.
TP is disposed.
Disposed of.
ಕೊಡಿ.
What's one matter for Monday, unnumbered matter. Gram Panchayat has issued demand notice. Challenge the constitutional validity of the 2020 and 2015 amendment with regard to
230 ಏನಪ್ಪ?
230 ಇಲ್ಲ Monday, unnumbered matter for Monday.
ಕೊಡಿ. ಅದ್ ಮೆನ್ಷನ್ ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ.
Urgency.
Yes.
List 2, total 6 matters.
List 2 serial number 1 to 20 will be relisted on 6/12.
My lords, may I submit?
1 to 20 ಅಲ್ಲಿ ಏನಾದ್ರು ಇದೆಯಾ ಹೇಳಿ.
Serial number 13, my lord.
ಹಾ.
Challenging the selection list. Similar matter in 3 matters, the stay has been granted. When this matter was earlier posted, the government directed to take the instruction and posted today. Subsequently, other 3 matters detailed heard and stay has been granted. There's urgency in
serial
this
number
matter
13,
also. 13, my lords.
13 ಫೈಲ್ ತರಿಸಿ.
9, serial number.
ಹಾ. 9 ಏನು?
District Court inquiry is challenged, my lords.
ಅದಕ್ಕೇನು ಅರ್ಜೆಂಟ್?
Allah, appoint our, if they are come and, my lord.
It will come on the regular day. 6/2 ಗೆ. 21 to 40, 7/2.
Lord, serial number 4.
ಹಾ.
Serial number 4, my lord, in second list.
ಹಾ.
My lord, senior house, my lord, there is a function, my lord, marriage is there on 18th or 19th, my lord, instead of 6th, my lord.
Serial number 4.
Please, it is connected matters.
At the request of counsel for the petitioner.
On 18th or
18th.
Serial.
Your lordship, serial number 21.
Just
Your lordship, serial number 21. I have complied with the office objections, your lordship.
yes. So what do we
Yesterday itself I have complied with the scrutiny. So Monday it has to be posted. The other matters are posting it on Monday, your lordship. Connected matters.
Monday also the judge is not sitting. It will be on
Okay.
7/2.
Yes, your lordship, please.
21 to 40, 7/2.
Serial number 23, my lord.
Your lordship, this office
Another
objection
one
may be
corrected matter,
overruled,
madam.
your lordship.
Madam, we are not passing any orders. If you are complied, registry will put up the note.
Serial number 23, my lord. Connected matter, my lord. Card along with my lord.
23.
Yes.
Connect with so and so and relist on 7/2. ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ 21 to 40?
There are some, my lords, in 14, there is interim order that needs to be extended.
Interim order ಎಲ್ಲಿದೆಯಾ extend ಆಗುತ್ತೆ. 21 to 40, anything else?
Next ಬರುತ್ತೆ.
ಯಾವುದು? 26. ಅವ್ರಿಗೆ ಇನ್ನ ಟೈಮ್ ಬೇಕಂತ. Counsel for Respondent number 7 seeks fund is granted 10 days time to file a statement of objection. Objections, if any, to be filed by 10th, relist on 13th. In an area 40 ge? Okay, 41 to 60. 41 to 60, repeat on 10-2. 61 to 78.
Serial number 70, my lord. 70, my lord. Short accommodation, my lord. There is an interim order against the.
It is coming up on
respondent.
11-2. 61 to 78 will be relisted on 11-2.
Earlier date, my lord. Next week, my lord.
Next. Yen ಹೇಳಿದಾರೋ ಅದೇ. Yes.
Please, my lord, please.
25, a request on 7. There are ballots in orders passed by this honorable court and they have been blatantly violated by the respondents. So ballots on 7th or 8th, if I may request.
11th, what will happen, Mr. Bullet? Let it be on 11th.
My lord.
61 to 78, 11-2.
Serial number 74, there is urgency.
ಏನು urgency?
Election has been completed. Voting rights was granted, voting rights was given. Now election has been over. Now it has to be results to be announced after counting.
That the regular court will decide whether to do it or not.
ಅಲ್ಲ,
ಇನ್ನ ಸರ್ವಿಸ್ ಆಗಿಲ್ಲ R5 and 6 ಗೆ.
ಅಲ್ಲ, I appear for the respondent number 5 in that 74.
74.1.
ಅದು ಅಷ್ಟರಲ್ಲೂ I am appear for the society.
74.1, 5 and 6 ಯಾರಪ್ಪ?
5 I appear, my lord.
You appear. Shri Girish V. Bhatt submit that you would be appearing for respond number 5. Registry is directed to print his name as such. R6.
Same.
R6 only, R5 and 6. Print his name as such. Same date.
My lords, serial number 19. Serial number 19, my lords.
ಯಾವ
List 2. List 2.
ಏನ್ ಹೇಳಿ?
Kindly on 10th, my lords.
Serial number
19.
19. ನೀವು ಯಾರಿಗೆ petitioner?
I am for petitioner, my lords.
19 relist on
10th, my lords.
10th.
my lords. Please.
My lord, serial number 71 in list 2, my lords. Kindly next week, my lords.
11-2. ಕೇಳಿಸ್ಕೊಳ್ಳಿ ಅದಕ್ಕೆ ರಿಪೀಟ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಎಲ್ಲಾರ್ದು ಆದ್ಮೇಲೆ ನೀವೇನು
64, 67, 68. Seeking madam candidate on Monday, my lord.
ಡೇಟ್ ಅದು
My lords,
ರೆಗ್ಯುಲರ್
list
ಎಮರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ ವಿ ವಿಲ್ ಟೇಕ್ ಇಟ್ ಅಪ್.
My lords,
ನೋ ಎಮರ್ಜೆನ್ಸಿ ಲೆಟ್ ಇಟ್ ಕಮ್ ಆನ್ ದಟ್ ಡೇಟ್.
list 2, serial number 8, my lords. ಇವತ್ತು ಮಾಡ್ತೀವಿ, my lords.
ಇವತ್ತು
Argument,
ಮಾಡ್ತೀವಿ. ಏನು
petitioner.
urgency ಏನು ಹೇಳಿ?
ಅದು ಟೆಂಡರ್ ಮ್ಯಾಟರ್ ಇದೆ, my lords.
ಯಾವತ್ತು ಟೆಂಡರ್
ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಮ್ಯಾನ್ ಪವರ್ ಸಪ್ಲೈ
ಯಾವತ್ತು ಟೆಂಡರ್ ಓಪನಿಂಗ್
ಆಗಿದೆ, my lords.
ಆಗಿದೆಯಾ? then no urgency.
Order has been also issued only in respect of service tax. 3% or 1%. It has to be verified.
ಅದ್ರಲ್ಲಿ ಬಹಳಷ್ಟು
Regular
rule
bench will take it. Yes.
List 1, adjournments. Page 8, 37 to 39. List 1 adjournments. Page 9, 40 to 44.
My lord, serial number 40, my lords. It has been moved by respondent number 4 and 5, my lords. I have requested him. It may be taken on 5th, my lords.
The request of counsel for the petitioner relist on 5th interim order earlier granted is extended.
Please,
next
grateful.
day.
Serial number 43.
3.
For respond number 2 and 3.
Yes.
I have informed the other side members.
43 are the request of counsel for respondents. Relist on ಏನಕ್ಕೆ?
ಅಲ್ಲ, ನನಗೆ I have not received any instructions from the party.
Relist on 11th February.
Please.
Page 10, 45 to 48.
My lord, serial number 47, my lord.
Yes.
Can you
have on
next week?
Inform ಮಾಡಿದಿರಾ?
I am for petitioner, my lord. Kindly have on a 4th, my lord.
47 at the request of counsel for respond number 2 and 3 relist on 4th.
Please.
4th, madam.
My lord. Fifth, my lord. Much obliged.
Page 11, 49 to 54.
My lord, serial number 49, my lords.
Yes. 49 ಹೇಳಿ.
My lords, I am for the respondent. I have informed the petitioners, my lord. Senior has been to Mahakum, my lords. May I request it on 6th, my lord, 6th or 7th?
ಇಂಥ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ ಕಷ್ಟ. The request of counsel for respond number 1 relist on 6th.
interim order
Interim order earlier granted is extended till next year. 49.
Serial number 53, Lordship.
50?
I am 53. Kindly I have it after 10th of February, Lordship.
Inform ಮಾಡಿದಿರಾ?
I have informed other side.
53 at the request of counsel for the petitioner relist on 13th February.
Lordship, kindly, these two matters may be connected.
Connect with so and so.
Page 12, 55 to 60.
Serial number 56, my lord. I am for petitioner, my lord.
Yes.
Next week, my lord.
Inform madidira?
Inform.
At the request of counsel for the petitioner, released on 13th.
List 1, pronouncement of order. Serial number 1.
Appear for the petitioner, ma'am.
Yes, Mr. Hegde. No grounds being made out, the petition stands dismissed.
2, J. Shetty.
No grounds being made out, the petition stands dismissed.
Orders 3, Lakshman T. Mantagani.
The petitioner is also
Your
dead.
Lordship, in this, I'm respondent number 4 to 8, Your Lordship.
Counsel for the petitioner seeks for and is granted 3 weeks' time to file necessary application, bring the legal representative of deceased, respond number 4 to 8, as also the legal representative of deceased, petition
Right,
number, sole petitioner.
Sole petitioner.
Relist on
Your Lordship,
20. Yes,
respond number 5 only had died.
respond number 5, 4 to 8, respond number 5. And sole petitioner.
4, S.L. Matti.
Sir, I will get this section.
3 weeks' time to file necessary.
Lords, may make one submission. Respondent number 7 is said to have passed away.
Yes.
The impugned order, my lords, is not, my lords, filed by the impugned order. The relief sought in this writ petition is not against.
I will get the
respondent number 7.
instruction. I will get.
Not required ಅಂತಾರೆ.
Not required.
ನೋಡ್ತೇನೆ ನಾನು. ಅಲ್ಲ ಅವ್ರು required ಇಲ್ಲ ಅಂದ್ರೆ ನನಗೆ ನೋಡ್ತೇನೆ ನಾನು ಫೈಲ್ ನೋಡ್ತೇನೆ.
Please.
Counsel for the petitioner seeks for and is granted 3 weeks' time to ascertain if the legal representative of deceased respondent number 7 are required to be brought on record. If so, to file such application.
Yes.
If not, to make a submission for dispensation.
Yes.
Released on 21st.
Please.
5, Dattatreya Hebbar.
Please, I am referring for petitioner. In this respondent number 4, notice is not served as he is expired. And there is no legal heir.
No legal error. Memo file ಮಾಡಿ.
And another
And
thing
AGA
is,
accepts notice for respondent number 1 and 2.
petition number 3 is expired.
Petition number 3
is expired.
and
I filed an
IAS
application.
during the pendency of the above matter. Petition number 3 expired on
Expired on.
10/8/2024.
Yes, sir.
Hence, IA number 1 of 2024 was filed on 3/12/2024.
Yes, sir.
The said application being in time, considering that the right to sue survives, the application is allowed. The person named therein are brought on record as P3A to P3C.
Yes, sir.
Counsel for the petitioner to carry out necessary amendment and file amended past title. R4 ge?
R4 is
No legal heirs.
no legal heirs.
Learned counsel for the petitioner has filed a memo stating that there are no legal heirs of respondent number 4, he not having been married nor
Yes,
not having been
yes.
married.
He died issueless, sir. He died issueless.
What about his wife?
She died earlier to him.
Respondent has no legal heirs. His wife having predeceased him and he having no legal heirs.
Yes.
His submission is taken on record. In that view of the matter, he submits that there is no requirement to bring the legal heirs of respondent number 4 on record. The submission is accepted at sole risk, cost and peril of the petitioner. If there are any legal heirs of deceased respondent number 4, they will not be bound by any order passed by this court. Relist on 13th.
Please.
6, Puneet Vadigir.
Pray for a week's
Few
time.
matters when there are so many objections.
Lordship, I am
To
proxy
start
counsel.
imposing costs.
No,
ನೀವೇ proxy appear ಆಗಿ ನೀವೇ ಕೊಡಿ.
as a last chance.
10 days time to comply with office objection. If not complied by 14th, relist on 19th for dismissal.
7, T.N. Osmane.
Same order.
8, Anandar Kolli.
Yes, submission.
Petitioner said so.
What is the submission? 27/1. Complete copy of order sheet.
Sir, I number 13, Honorable Court had dismissed, sir.
Learned counsel
that
for the
only.
petition submit that the relevant portion of the order in OS number 94 of 16, which is under challenge, has been produced, and as said, the complete order sheet not being required is not produced. His submission is accepted. Office objection serial number 27-1 is overruled. Yes?
Yes, I number 13 is Honorable Court is rejected, sir. Dismissed.
Ready na?
No, no lordship.
You're not ready. Relist on 6th.
Nine, Jagdish Patil.
For petitioner,
This is for the respondent.
they are seeking for time, my lords. Sangram sir.
Respond number 1.
Please.
On behalf of respondent, on 7th.
On 5th, my lords.
Relist on 6th. It is made clear that no further adjournment would be granted. If arguments are not advanced on that date, matter would be taken up for consideration on the basis of submission of counsel for the petitioner.
10, Anandar Kulli.
10 days time to comply with office objection. If not complied by 14th, relist on 19th for dismissal.
11, Kel Patil.
Same order.
Monday, my lords, emergency in the matter.
Yavdu?
11, my lords. Monday, my lords. Adu onde objection ide, comply ಮಾಡಿ.
KL Patil.
Yes, please, your lordship, appearing on behalf of the senior lords.
Relist on counsel for the petition seeks for and is granted 2 days time.
Please, your
to
lordship.
comply. Relist on 4th.
Please, your lordship.
12, Ramchandra Mali.
Appear, my lord, for the petitioner.
Yes.
My lord, petitioner is a
Same
society.
office objection first here.
My lord, the office has
copy at 23.
raised an office objection regarding, my lord, production of layout map, which is not required.
The counsel for the petitioner submit that the objection raised as regard page 23 at annexure B is as regards a sketch as a plan sanction. He submit that he would not be relying on the same. In that view of the matter, office objection at serial number 28, 27 is overruled. Yes.
My lord, by annexure C, my lord, the government has issued a license, my lord, to the petitioner association, my lord, society to, my lord, establish a private, my lord, market to conduct, my lord, business in notified agricultural produces under the provisions of, my lord, Karnataka Agriculture Produce Marketing Regulation and Development Act, my lord, 1966. This is, my lord, dated 16.
They are asking for a permission to conduct the business.
Allah,
You have to hear them.
Allah, license has been granted.
He'll hear them. And then we can't give an ex parte interim order for that.
Allah, now what is done is, they are, my lord, restraining me, my lord, from conducting business in green ginger and garlic, saying that those are not vegetables.
Let us hear them, why they are saying
There is
that.
a Supreme Court, my lord, decision on the point as back.
Mr. Malli, can we give a ex parte ad interim order directing them to permit you to sell?
Now, my lord, at least.
Allowing the petition.
I may
You
not,
don't
my lord,
want notice, then we'll dismiss it.
at least
And
one
counsel
request.
for
Can
the petitioner opposes issuance of notice. Dismissed.
One request,
Current
alternative.
AGA accepts notice for respondent number 1, 2, and 3. He seeks for and is granted a week's time to make his submission. Relist on 7th.
At least, my lord, let them not precipitate. They have-
You can't sell if there is a restriction.
13, HM Darigon.
10 days time to comply with the office objection. If not complied by 14th,
Comply
relist
during-
19th for dismissal.
Comply during course of the new of urgency move the matter.
Week's time, relist on 6th.
Week's time in 14,
10 days time, if not complied by 14th, relist on 19th for dismissal.
15, Sabil Ahmad.
Colleague in VC makes submission. My colleague in VC, 192 a KLR notice, my lord.
Yeah.
Abrar is online, my lords.
Typed copy of B and D to be furnished with self-attestation.
The readable and legible, my lord, basis.
Page number.
Please, your lordship. Lords, page number 20, my lords, and page number.
A peril of annexure B and D indicates that they are legible. Hence, office objection at serial number 28 is overruled. Yes,
My
sir.
lords, serial number 52, office objection at serial number 52 is with regard to a extent of land being different in annexure C and annexure D.
There is only one objection as regards legibility, which we have overruled.
Much obliged, my lords. My lords, the petitioner is in occupation of land bearing survey number 867B, measuring 3 acre 41 cents of Ballari, Kolgal village, my lords, Ballari Taluka district. He had applied for regularization of his occupation by filing form number 57 with annexure B. With annexure C, 77,
No order has been passed on Form 57.
No, I'll just make one submission. On 7th July 23, they issue inquiry notice calling me for appear and answer the form number 57 by fixing the date on 15/7. On the very next day, 8/7, they again issue a notice under section 192A KLR Act.
Has
Asking
an
me to
order
be
been, Mr. Abrar, you should answer the question. Has an
No
order
orders have been passed. No orders have been passed, my lords.
And AGA accepts notice for respondent number 1 to 4. The operation of the notice dated 8/7/2023 issued by fourth respondent annexure D is stayed till the next date of hearing. Wherein AGA is directed to inquire into and make a submission as to whether any order has been passed on form number 57 submitted by the petitioner by next date. Released on 13th.
16, Sabil Ahmad.
Petitioner plaintiff before this court, my lords.
Maintainability.
As my lords, I am seeking direction to the trial court, my lords. Suit in the year 2019, I filed IA number 1, my lords, has not been disposed, my lord, till today, my lords. My lord, my kindly.
Okay. 39(1) and 2.
ಇಲ್ಲ ಆರ್ಡರ್ ಏನ್ ಮಾಡಿಲ್ಲ ಅದ್ರ ಮೇಲೆ.
ಅದಕ್ಕೂ 39(1) and
lords, my submission to this court, but this court might direct the trial court to dispose of the IA, my lords.
You'll have to issue notice and let it come.
Lords, only for the court, my lord, not the other party. I'm not having any prayer against the respondents, my lords. Page number 57 for a moment may kindly be perused.
Petitioner is before this court seeking for the following reliefs. Notice to respondent is dispensed with in view of the proposed order to be passed. The grievance of the petitioner is that despite IA number 1 for under order 39 rule 1 and 2 of the Code of Civil Procedure having been filed on 5/2/2019, no orders have been passed thereon till date. The trial court will be well advised to comply with the direction issued by the Honorable Apex Court in.
My lords, there are 3 judgments I have quoted, my lords.
ಒಂದೇ ಹೇಳಿ ಐದು
Lords,
ಯಾರದು?
A. Venkata Subbaya Naidu versus
Subbaya Naidu. ಎಲ್ಲಿದೆ ಅದು?
Page 7, my lords, may I request.
Page
7, my lords, 7 of the petitioner.
By the Honorable Apex Court in A. Venkat Subbaya Naidu versus S. Challappan in 2007 SCC 695 and pass necessary orders on the said application at the earliest. With the above observation, the petition stands disposed.
May I request you for time limitation, my lords. For the reason that, my lord.
View of that under 30 days.
Please, your lords.
17, Shukumar Badwadgi.
Lord, I have filed an application for 17B wages, my lord.
Mr. Badwadgi.
And it is covered by judgment, my lord. Last time, my lord, has passed. The only point they have raised is training.
Dispose ಮಾಡ್ಬಿಡು. ಇಲ್ಲಿ ಅವರು ಪಾಸು.
That Veena Hegde appears, my lord. It appears they have filed. She has filed wakalat in the place of.
Where is she? Paso.
18,
Post before a bench of which SGRJ is not a party.
19,
Lord, in 19, my lord, I appear for the petitioner, my lord.
Representing housing board, I have 2 weeks time to file objection.
27 and 28, Nandish.
My lord, that is, my lord, insofar as annexure B and annexure F, my lord, they are legible copies, my lord. Annexure B at page 64, my lord.
18, 19. Why not 2 weeks time?
Perusal of, just one more. Perusal of annexure B being a notification indicates that the same is legible. Hence, office objection at serial number 27 is overruled.
Please. And my lord, annexure F, my lord, page 96.
152 to 157.
That's a part of annexure F, my lord.
ಇದು ಕಾಣಿಸಲ್ಲ ನಂದೀಶ್ ಇದು.
I'll file it, my lord. Your lordship may fix a date, my lord. I'll file it.
Seeks for and is granted a week's time to file a readable copy of page 152 to 157 of annexure F.
I'll do it.
Ranking of the parties.
My lord, that we have corrected, my lord.
Counsel for the petitioner submit that he has corrected the ranking of the parties before the trial court registry to verify. Counsel for respondent.
Could it be on 10th of February, my lord?
6 time.
2 and 3 seeks for a short accommodation to get ready and address his arguments. Released on 6th, 7th
10th
February.
Please 10th.
10th February.
10th, obliged, please.
20, Sadiq.
Petitioner, my lord, I have made an application for direction. My lord, kindly turn to ink page 9. My lord, petitioner is an ex-serviceman. My lord, my lord, he was in possession and cultivation of land in survey number 265/1, measuring 4 acres. My lord, by this order, my lord, they have, my lord, granted, my lord, occupancy, my lord, grant in survey number 109 for, my lord, 1 acre. Now, my lord, they are, my lord, started to, my lord, put the, my lord, polls, these officials of respondents.
Has cancelled the grant.
Yes, ma'am. My lord, kindly see, my lord, during pendency, my lord, they have started to, my lord, where the property 265/1. My lord, kindly see, my lord, they have come with police, and my lord, they have started to dig the poles in the, my lord, premises of petitioner, where she is cultivating.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ?
ಅಲ್ಲಿ ಪೋಲ್ಸ್ ಡಿಗ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಏನಕ್ಕೆ ಪೋಲ್ಸ್?
My lord, I don't know, my lord, the reason.
ಇದು
Therefore, I sought not to change the, my lord, alter the nature of the property.
Yes, Mr. Kanush.
Annexure F may kindly see, Lordship. Annexure A, your Lordship, ink page 10, Lordship. In that, your Lordship, the 4 acres regard, it is observed in the order that, your Lordship, he is having 4 acres. But it was not cancelled. Only, your Lordship, in the operative portion, 1 acre is granted to the petitioner herein. How is affected by this order? From the.
Where is your grant order for 4 acres?
What they say, there is only entry in record of rights.
Where is your grant order for 4 acres?
Annexure B, your Lordship, only it is of 2001, 2002.
Presently, I don't have, but in the order they say, there is an entry in record of rights, but there are no documents to show that there is, my lord, a grant in favor of petition.
Your claim is that you are granted 4 acres.
Yes.
But your Lordship, Annexure B.
Date ಏನು ಹೇಳಿಲ್ಲ ನೀವು.
ಇಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, page 9. Page 9. My lord, they have put the date of this number.
ನೀವೇನು ಹೇಳಿಲ್ಲ.
Register number 24/84/85 ದಿನಾಂಕ 36/84 ರಂದು.
Where is your grant order?
But they say there is no, my lord, documents to show that there is a order.
ಕೇಸ್ ಎಲ್ಲ ನೀವ್ ಹೇಳ್ಬೇಕು ಎಲ್ಲಿ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಅಂತ.
ಆದ್ರೆ my lord, from
ಅವ್ರು ಹೇಳ್ತಾರೆ 1 ಎಕರೆ ಇದೆ ಅಂತ, ನೀವ್ ಹೇಳ್ತಾರೆ 4 ಎಕರೆ.
1 ಎಕರೆ ಅಲ್ಲ, ಬೇರೆ ಕಡೆ 1 ಎಕರೆ ಕೊಟ್ಟಿದ್ದಾರೆ. They have given in another survey number.
ನೀವು ಇದ್ರದ್ದು ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿ?
Grant order, my lord, I'll take instructions.
After arguing for some time, learned counsel for the petitioner seeks for and is granted. ಎಷ್ಟು ದಿನ?
1 ವಾರ.
A week's time to furnish the grant order in favor of the petitioner for 4 acres of land in survey number 265/1 of ಯಾವ village?
Abbigeri village.
Abbigeri village, Rohan Taluk, Gadag district. If such grant order is not produced, adverse inference would have to be drawn and matter proceeded with. Released on 10th.
Till then, let them not do anything.
ನಿಮ್ ಗ್ರಾಂಡ್ ಆರ್ಡರ್ ಇಲ್ಲ. ನಿಮಗೂ ಗೊತ್ತು. ಸುಮ್ಮನೆ 10 ದಿನ ಕೊಡ್ತಾ ಇರೋದು ಅಷ್ಟೇ.
21, M.V. Hiremat, Mallikarjun Swami.
Preparing for the.
And for the petitioner, may I
filed
request?
this application seeking for vacating, my lord, the interim order. Lord, without challenging the original grant order, they are, my lord, harping only on the mutations, my lord, which have been, my lord, granted, which have been entered, my lord, subsequent to the sale. The original grant order ಇನ್ನೂವರೆಗೂ challenge ಮಾಡಿಲ್ಲ, and it is covered by the judgment of this honorable court, which I have produced, my lord, along with my statement of objection at annexure R9, page number 59. Para number 9 of the said order, madam. Page number 68. Page number 68, para number 9.
Yes.
In that view of the matter, this court is of the considered opinion that the special deputy commissioner could not have initiated the proceedings under section 136(3) of the Act 1964, and he could not have directed the deletion of the names of the grantees or the subsequent purchasers from the land records without getting the original order passed under the Act 1954 set aside in the manner known to law. Moreover, as rightly pointed out by the learned senior counsel appearing for so and so, this court in at least 3 cases and connected matters held on 7/2/2002 has held that even where limitation is not prescribed and so motu powers are invoked for setting aside an order, the same may be done within reasonable time. This court has noticed the judgments of Honorable Supreme Court so and so, and came to the conclusion that even if
Until
the
date grant order is not challenged or set
no.
aside.
My request for weeks accommodation, my lord, I seek
nowhere
any-
they are challenged.
The submission of Shri T.M. Nadaf, learned counsel, appearing for respondent number 7, is that the grant order in favor of respondent number 7 has not been challenged.
The ancestor of respondent number 6.
Ancestor in favor of the ancestor of respondent number 7.
6. I am the
Not
purchaser.
having been challenged. The mutation carried out in favor of respondent number 7 could not have been challenged by the petitioner. And in that regard, he relies upon the decision of a coordinate bench of this court dated 31/1/24 in WP number 41881 of 2019. Faced with the above situation, learned counsel for the petitioner seeks for and is granted a week's time to obtain instruction and make a submission as to whether the grant order has been challenged. If so, whether the same has been set aside.
And one submission.
If-
Once they have challenged.
Just to say, if the grant order continues to be enforced, the above petition would not be maintainable.
And once they have challenged, my lord, the grant order by the tribunal before the assistant commissioner. Assistant commissioner said that I am not the authority to say.
Okay, set aside.
Please.
We list on 11th.
Please.
22.
In the meanwhile, office objections to be complied with, failing which the petition would be liable to be dismissed.
Please.
and not
22.
In this
Suraj
case, my
Mudhol.
my request, ma'am. Mallikarjun Swamy name may be deleted, ma'am.
ಎಲ್ಲಿದೆ ಮಲ್ಲಿಕ್ ಇದ್ರಲ್ಲ
Please.
T1 ಅಲ್ಲಿ ಯಾರ ಹೆಸರು ಇರ್ಬೇಕು ಇವಾಗ?
M.V. Hiremat and Umesh P. Akarki. Mallikarjun Swamy B. Due to ours.
Registry Act, delete the name of Shri Mallikarjun Swamy B. Hiremat as that appearing for the petition. 22.
22.
During the pendency of the matter, respondent number 6 is expired. As such, IA 1 of 25 has been filed. Issue notice on IA 1 of 2025, returnable by 24th April. Process fee and copies to be furnished by end of day 5th February.
23. S.K. Kaikmat.
My lord, serial number 23, 27 and 54 are connected matters. My lord, there is one more matter required to be connected.
23, 24,
23, 27, 54, my lord.
27
and 54.
54
And one more matter is required to be connected, my lord.
to each other, connect so and so with it, relist on 19th March.
My lord, in serial number 27, I accept notice for respondent 1 to 4.
Notice.
27 ದಲ್ಲಿ ಆಗಿಲ್ಲ.
27 learned AG accepts notice for respondent.
1 to 4.
ಯಾರಿಗೂ ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ. ಅದ್ರ private parties in the connected matter, they is served unrepresented.
ಸದ್ಯಕ್ಕೆ ಕನೆಕ್ಟ್ ಮಾಡಿ, then we'll order notice.
Yes, ma'am.
Sorry, no. Serial number 22, interim order.
22 interim order.
24. Nandish Patil.
Serial number 24, my lord, I appear for petition number.
Yes.
My lord, I am seeking, my lord, dispensation of production of certified copy, my lord.
And what are S and W?
My lord, they are the impugned orders, my lord.
Any dispute about these orders?
No.
Accepting the reasons stated in support of IA 1 of 24, the production of certified copy of Annex S and W is dispensed with in view of there being no particular objection as regard the veracity of the said order. IA 1 of 24 is allowed. Yes.
Please. My lord, the petitioner, my lord, is a trust, my lord, running a high school. My lord, there was a high school, my lord, in Bangalore, my lord, which was an aided institution where, my lord, the strength of the student, my lord, was reducing. My lord, at that juncture, my lord, we requested them, my lord, to shift the school, my lord, from Bangalore to Hubli. My lord, we completed all the legal formalities of shifting, my lord, and the orders of shifting were also granted in our favor. My lord, after the orders being granted, my lord, unilaterally, my lord, they withdrew the transfer order. My lord, we challenged it before this honorable court, my lord. Your lordship may kindly see page 58, my lord. There was an interim order, my lord, which was granted. Page 58, please, my lord.
58.
Annexure M, my lord. The interim order, my lord, your lordship may kindly stay as prayed for, my lord, in the last line. During pendency of this, my lord, matter, my lord, they, my lord, in fact, cancelled the shifting order itself. Again, my lord, we approached this honorable court, my lord, and an interim order was granted. My lord, in the first matter, my lord, where interim order was granted, it came to be disposed of, my lord, by annexure P, my lord, page 63. Page 63, my lord, para 6 onwards, my lord, would be relevant.
That came to be quashed.
It came to be allowed, my lord. The writ petition was allowed. It came to be quashed, my lord. And liberty was also reserved, my lord. Your lordship may kindly see point number 3, my lord. Liberty is reserved to the respondent to issue notice to the petitioner before taking any decision with regard to withdrawal of the order, permitting to transfer the school from Bangalore to Hubli rural and thereafter pass necessary orders. My lord, subsequent to this, my lord, the teacher's salary, my lord, was not released. And again, my lord, we approached this honorable court, my lord, vide annexure X, my lord. Your lordship may kindly see page 87. My lord, this honorable court, my lord, issued a mandamus, my lord, at para 8. My lord, directing them to, my lord, your lordship may kindly see para 8, my lord, page 91.
Yes.
The unilateral decision taken by the state government to revoke the order of transfer has been stayed by this court. Perhaps it is because of the revocation of the transfer, the state has not paid the amount so far. The state government shall reimburse the salary of the petitioners because the decision taken to transfer petitioners is subject to providing facility regarding granting aid. Lord, subsequent to this, my lord, your lordship may kindly see annexure Y, my lord, page 93. We filed contempt, my lord, and in the contempt petition, my lord, the salaries were paid, and my lord, the contempt came to be dropped. My lord, after this, my lord, the second round of my lord, after my lord, liberty was reserved, my lord, the second round started, in which, my lord, now they have permitted to transfer, but my lord, the grant in aid, my lord, has been withdrawn. That is our grievance before this honorable court. In fact, my lord, if your lordship sees, my lord, in the 2015 order where it was transferred, grant in aid has been continued, my lord.
Yes.
And my lord, for grant in aid, my lord, section 53 of the Education Act, there are only certain circumstances under which, my lord, the grant in aid can be withdrawn. Here there is no circumstance, my lord.
Yes.
Lord, one submission. As per the impugned order at page annexure S, page 77. My lord, may I take it lordship at page 79?
Yes.
Yes. Before the operative portion of the order, my lord, may I read? ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ದಿನಾಂಕ 16/3/21 ಆದೇಶವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಎಪಿ ವಿದ್ಯುತ್ ಟ್ರಸ್ಟ್ ಬೆಂಗಳೂರು ಈ ಆಡಳಿತ ಮಂಡಳಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಎಪಿ ಪ್ರೌಢಶಾಲೆ ಅಶೋಕ್ಪುರಂ ಬೆಂಗಳೂರು ಈ ಶಾಲೆಯನ್ನು ಸೇವಾ ಆಶ್ರಮ ಟ್ರಸ್ಟ್ ವಿಶಾಲ್ ನಗರ್ ಹಳೆ ಹುಬ್ಬಳ್ಳಿ ಧಾರವಾಡ ಜಿಲ್ಲೆಯಲ್ಲಿ ಈ ಸಂಸ್ಥೆಗೆ ಹಸ್ತಾಂತರಿಸಲು ಹಾಗೂ ಶಾಲೆಯನ್ನು ಬೆಂಗಳೂರು ನಗರದಿಂದ ಧಾರವಾಡ ಜಿಲ್ಲೆಯ ಹುಬ್ಬಳ್ಳಿಗೆ ಸ್ಥಳಾಂತರಿಸಲು ಈ ಶಾಲೆಯನ್ನು ಅನುದಾನ ರಹಿತವಾಗಿ ನಡೆಸಲು ಷರತ್ತುಗೊಳಪಟ್ಟು ನಡೆಸಲು ಅನುಮತಿ ನೀಡುವ ಬಗ್ಗೆ ತೀರ್ಮಾನಿಸಿ ಕೆಳಗೊಂಡಿದೆ. ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಅಂಶಗಳನ್ನು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ರಿಟ್ ಪಿಟಿಷನ್ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕ 16/3/21 ನೀಡಿರುವ ಆದೇಶರನ್ವಯವಾಗಿ ಎಪಿ ವಿದ್ಯುತ್ ಟ್ರಸ್ಟ್ ಅಶೋಕ್ಪುರಂ ಬೆಂಗಳೂರು ಈ ಆಡಳಿತ ಮಂಡಳಿಯಿಂದ ನಡೆಯುತ್ತಿರುವ ಎಪಿ ಪ್ರೌಢಶಾಲಾ ಅಶೋಕ್ಪುರ ಈ ಶಾಲೆಯನ್ನು ಸೇವಾ ಆಶ್ರಮ ಟ್ರಸ್ಟ್ ವಿಶಾಲನಗರ್ ಹಳೆ ಹುಬ್ಬಳ್ಳಿ ಧಾರವಾಡ ಈ ಸಂಸ್ಥೆಗೆ ಸ್ಥಳಾಂತರಿಸು ಮತ್ತು ಹಸ್ತಾಂತರ ಮಾಡಿ ನಂತರ ಹಿಂಪಡೆದಿರುವ ದಿನಾಂಕ 30/9/2015 ಆದೇಶವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯವು ವಜಾಗೊಳಿಸಿರುವುದರಿಂದ ಮತ್ತು ಎಪಿ ಪ್ರೌಢಶಾಲೆ ಶಿವಾಲಯದ ಅಂಚಟಗಿರಿ ಹುಬ್ಬಳ್ಳಿ ಇಲ್ಲಿ ಶಾಲೆಯ ನಡೆಯುತ್ತಿರುವುದರಿಂದ ಈ ಶಾಲೆಯನ್ನು ಅನುದಾನ ರಹಿತವಾಗಿ ನಡೆಸುವ ಷರತ್ತುಗಳನ್ನು ಪಟ್ಟು ಸರ್ಕಾರದ ಪತ್ರ ಸೋ ಅಂಡ್ ಸೋ ದಿನಾಂಕರಂದು ಸಮ್ಮತಿ ನೀಡಿರುವ ಹಸ್ತಾಂತರ ಮತ್ತು ಸ್ಥಳಾಂತರ ಅನುಮತಿಯನ್ನು ಮುಂದುವರಿಸಿ ಆದೇಶಿಸಿದೆ. So my lord, unaided in view of
No, it was aided. How do you make it
my lord,
unaided?
my lord, the institution which was transferred from the Bangalore, that was aided. The institution to which the now
2015 when you permitted the transfer, it was transferred.
that was questioned by the petition, the teachers before this honorable court. We are not ready to go. So for that reason, my lord, this honorable court passed an order that the order which has been passed transferring that was been withdrawn.
What is the reason? There's no reason given.
For that simple reason, my lord, on the last earlier occasions also, I made a submission. The impugned order which has been passed in view of section 53 of the Education Act, an opportunity has to be given to the petitioner. That has not been called. So it was time to time it was adjourned. Pursuant to which, my lord, annexure W, that is also which has been questioned, wherein a midday meal benefit has been withdrawn by the BEO. But as per the law, my lord, BEO has no right to withdraw the midday meals. It is the chief executive officer of the Jilla Panchayat. So this order has to be set aside and annexure S has to be set aside and remand for giving an opportunity of hearing.
What is the reason for all this?
Alla reason antandre, the only reason is my lord, pursuant to the direction issued by this court, the annexure S has been issued.
ಅದಕ್ಕಿಂತ ಹಿಂದೆಯಿಂದ ಏನ್ ರೀಸನ್ ಇದು?
ಅಲ್ಲ ಅದನ್ನ ಏನು ಬರ್ದಿಲ್ಲ ಅವರು.
Why are you coming in the way of the school functioning from 2015?
My lord, not insofar as Bengaluru institution, we are not. Only insofar as the institution which has been run at Hubli, we are objecting since it is an unaided institution. It is not an aided institution.
In where that order 2015 ತೋರ್ಸಿದ್ರು?
My lord, it is at annexure L, page 56. That is on 30th/9/2015. That is the original order.
So illi,
Please.
it was with the aid that it was transferred.
Yes, ma'am. But in view of the objections made pursuant to the transfer, the teachers approached this honorable court. Were not ready to.
Education Act. Is it part of section 53 for you to withdraw?
Please.
Is that a reason under section 53?
No.
Then how can you withdraw once you have granted it?
But
My lord, section 53, if your lordship sees, my lord, nearly, my lord, 7 reasons have been specified under the act itself, my lord. Your lordship may kindly see, my lord, fails to fulfill all or any of the conditions of the grant, denies admission to any citizen on the grounds only of religion, race, caste, language, or any of them, allows any employee of the institution to take part in any agitation. Lord, nothing of this has happened. Lord, your court is not audible.
My lord, the
litigations are over. But litigation ಮಾಡಬೇಕು ಅಂತ?
We are not in proceeding with regarding to litigation is concerned. The school which was shifted was aided. Now where they
already suffered an order from this court.
Yes, my lord.
You are still trying to overreach the court.
But my lord, may I take it to lordship? The liberty was reserved to the state. At page 68, liberty is reserved to the respondent to issue notice to the petitioner before taking any decision with regarding to the withdrawal of the order permitting to transfer.
Now you have permitted the transfer.
Yes, that is annexure. Yes.
Now, what you have done is only withdrawn the grant in aid, which can be done only.
That has been quashed by this honorable court already.
Which you can do only in terms of 53(1).
Yes, yes.
Any ground for that?
No.
Then?
The reason only ashte bardidaru as per annexure H.
This is an abuse of power. You are targeting the school.
No. We are not.
At the instance of somebody else or what?
No, that is not the.
ಇನ್ನೇನಾದ್ರು ಪಕ್ಕದಲ್ಲಿ ಸ್ಕೂಲ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಯಾವ್ದು ಇಲ್ಲ, ಇರೋದು ಅದೇ ಒಂದೇ ಸ್ಕೂಲ್.
ಅದ್ರದ್ದು ಇನ್ನೇನು ರೀಸನ್ ಇರಲ್ಲ ಇದು.
I am not.
You can't be targeting them like this.
No.
Should be functioning.
That is not the.
The teachers had a problem that has been resolved.
Yes, sir.
You can't be doing this.
Please.
Petitioner is before this court seeking for the following reliefs. This is a classic case of abuse of powers vested in the respondent officials being made use of against the petitioner institution. Earlier, AP Vidyavati Trust was running a Kannada medium high school at AP Praudashale, Ashokpuram, Bengaluru. Since the strength of students in the said school was dwindling, the same being a Kannada medium school, the petitioner sought for transfer the school to Hubli rural. Accordingly, an application had been made to the education officer at Hubli, accompanied by necessary documents. The said application being considered, a recommendation was made by the additional commissioner for such shifting. The respondent and the petitioner made all arrangement for construction of the school and providing facilities, as also filing necessary applications for grant of recognition, etc., which came to be allowed. Finally, by order dated 30/9/2015, the shifting of the school from Ashokpuram, Bangalore to Hubli rural, with the transfer of the school from APV Trust to the petitioner trust, was approved on 30/9/2015 at annexure L. It is subsequent thereto that the problems have started for the petitioner. Inasmuch as the respondents had cancelled the transfer or order of transfer, which required the petitioner to approach this court in WP number 111924 of 2015, which initially came to be stayed by this court, and subsequently the writ petition came to be allowed on
Lord, it was allowed on 16/3/2021.
16/3/2021, reserving liberty to the respondents to issue necessary notice and thereafter pass orders. A show cause notice having been issued on 8/6/2022, the petitioner submitted a detailed reply. However, the reply was rejected, and on 5/1/2024, reply was partially rejected, and while the impugned order dated 5/1/2024, though the shifting was permitted, the grant in aid was revoked. It is challenging the same. The petitioner is before this court.
Please.
Where is that earlier order of transfer?
Lord, that is Annexure L,
Annexure L.
page 56. That was the first order.
Annexure L is dated
30/9/2015.
ಅದು cancelling.
ಇಲ್ಲ, transfer, shifting of school.
66.
56.
56, please.
The petitioner school being permitted to, the concerned school being permitted to be transferred by order date 39/2015, along with the grant in aid.
No.
It is impermissible for the state to revoke the grant in aid unless there is any violation of subsection 1 of section 53. In the impugned order at annexure,
Yes.
dated 5/1/2024 at annexure, yes, there is no particular reference or allegation which have been made insofar as violation of subsection 1 of section 53, except to state that the transfer is permitted sans the grant in aid. The respondent number
1.
had no power to hold that the grant in aid would be cancelled unless there is any violation which comes within the purview of subsection 2 of section 53. Even if such grant in aid was required to be cancelled, a separate notice as required under section 53 was required to be issued, and thereafter necessary action was to be taken. Instead of doing so, the first respondent, while reaffirming the transfer, has cancelled the grant in aid, which is not permissible. That apart, the block education officer has also cancelled the midday meal scheme facility which was available to the petitioner school while its order dated
My Lord, order 12/6/24.
2024. He not having any authority to do so, it being the chief executive officer of the concerned panchayat who would have the authority. The manner in which the respondents have acted, as observed above, clearly indicates a gross abuse of the power vested with them in targeting the petitioners from running the school from the year 2015 till now, resulting in multiple litigation which could have been well avoided. In that view of the matter, the respondent number 1 ಇದು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
Allah, the reason for passing that, page 62 may kindly be seen. My Lord, may I read?
Yes.
At ಉಲ್ಲೇಖ second para, my Lord. ಉಲ್ಲೇಖ 2 ದಿನಾಂಕ 17/5/2000 ಶಾಲೆಯ ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಕಾಯ್ದೆ ಸೆಕ್ಷನ್ 11(5) ಷರತ್ತುಗೊಳಪಟ್ಟು ಮತ್ತು ಷರತ್ತು ಭಾಗ ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಮತ್ತು 3 ಸಂಬಂಧಿಸಿ ಸಂಸ್ಥೆ ಹೊಸ ಶಾಲೆಗೆ ಮಾನ್ಯತೆ ಕೋರುವಂತೆ ಹೊಸದಾಗಿ ಮಾನ್ಯತೆ ಕೋರತಕ್ಕದ್ದೆಂದು ಮತ್ತು ಕರ್ನಾಟಕ ಶಿಕ್ಷೆ ಕಾಯ್ದೆ 83 ಅಡಿಯಲ್ಲಿ ರಚಿಸಲಾದ ನಿಯಮಗಳನ್ನು ಶಾಲೆಯನ್ನು ನೋಂದಣಿ ಮಾಡತಕ್ಕದ್ದೆಂದು ತಿಳಿಸಲಾಗಿದೆ. ಈ ನಿಯಮದಂತೆ ಹಸ್ತಾಂತರ ಮಾಡಿಕೊಂಡ ಸಂಸ್ಥೆಯು ಹೊಸದಾಗಿ ಸಂಬಂಧಿಸಿದ ಉಪನಿರ್ದೇಶಕರು ಸೋ ಅಂಡ್ ಸೋ ನಿಯಮ ನಮೂನೆ 9ರಲ್ಲಿ ಶಾಲೆಯನ್ನು ಹೊಸದಾಗಿ ನೋಂದಾಯಿಸಬೇಕು ಮತ್ತು ಹೊಸದಾಗಿ ಪ್ರಥಮ ಮಾನ್ಯತೆಯನ್ನು ಪಡೆಯಬೇಕು ಮತ್ತು ಈ ಶಾಲೆಯನ್ನು
Granted that permission, must they was that?
ಅಲ್ಲ ಇಲ್ಲಿ it is not a grant in aid school which is transferred. So it is treated as a new school.
It's a grant in aid school which has been transferred. It can't be treated as a new school. In that view of the matter, I pass the following order. Yes, sir, writ petitions allowed, a certiorari is issued, the impugned order dated 5/1/24, bearing so and so at annexure S, passed by respondent number 1. Respondent number 1 is quashed. The impugned order dated 12/6/2024,
By respondent number
passed
3.
by respondent number 3 at annexure W is quashed. The transfer having been effected with grant in aid, wide the order dated 39/2015 at annexure L. A mandamus is issued directing the respondents to afford the grant in aid as available for AP Praudashale Ashokapuram to the present school at Hubli. Needless to say, the petitioner would have to follow the terms and conditions of the grant in aid.
Please, could there be a time duration fixed for them to comply?
But we have to verify the condition, terms and conditions that has to be followed. ಮತ್ತೆ ನಾಳೆ ಈಗ ಅಲ್ಲ
ಏನು ವೆರಿಫಿಕೇಶನ್
ಅಲ್ಲ
ಮತ್ತೆ ಇನ್ನೊಂದು ಲಿಟಿಗೇಷನ್ ಮಾಡಬೇಡಿ within 60 days.
Please.
Oblige.
25 NR Kuppelur.
I beg for respondent. I have
This is including applicant, Sangamesh Kullapanav.
Including applicant.
For the petitioner's counsel.
Who is the impleading applicant? Impleading application in?
I am the impleading applicant, man.
Yes. Why do you want to implead?
I am the subsequent purchaser of the property, man. The suit property.
KLR. Any objections?
His rights are not being decided in these proceedings for this simple reason. My challenge is with regard to the jurisdiction of the assistant commissioner to have entertained an appeal at the instance of the respondent before this court. Law does not provide for such an appeal at all. If ultimately the court holds that proceedings before the assistant commissioner was illegal and contrary to the known canons of law,
Yes, really.
it doesn't affect.
We'll consider this and then decide whether to implead him or not. On merits, you can submit.
Right. Let him be on record, let the matter be taken up minutes.
He can come on record.
Yes.
Land counsel for the petitioner submit that he has no objection for allowing IA2 of 2024. In that view of the matter, accepting the reasons stated in support of IA2 of 24, the said application is allowed. The person named therein is brought on record as respondent number 7. Counsel for the petitioner to carry out necessary amendment, file amended cost title. In IA2 of 24, any objections on IA2?
We have filed objection.
They have
Let the
filed
matter be taken up on merits, my lord, sir.
Statement ಆಯ್ತು. Vacating stay. The application for consideration of application for vacate stay would include, would mean a finding on the merits of the matter. As such, IA1 of 24 will also be taken up along with the merits of the matter. Yavat?
Subject to convenience of the court, if it is possible, I have come, I'll make my.
Today only it is fixed for final argument. Last occasion you were. Yes, ma'am.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ?
Maybe on
10
25 minutes.
ಮತ್ತೆ ಹೇಳಿ, ಇಬ್ರು ರೆಡಿ ಇದ್ರೆ ಏನಂತ? ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ವಿಲ್ ಅಡ್ಜರ್ನ್, ರೆಡಿ ಇದ್ರೆ ಅಂತ ಹೇಳಿ.
Lord, the petitioner before my lords, the Khatadar of land bearing revenue survey number 830/1 of Ranebennur. His name was mutated in the revenue records by the Tahsildar consequent upon death of
his mother, adopted mother, which was pursued after the disposal of RSA by this Honorable Court. Kindly come to ink page 44 of the writ papers.
So RSA has been allowed.
How? RSA ಒಳಗೆ my title of Channava became perfect.
You adopt your mother.
Yes.
Yes.
Because she had died during the pendency of the RSA. He had come on record as LR. And after disposal of RSA, IHC entry was got made, inheritance. It was done by competent authority, that is Tahsildar. That's all of a sudden, the assistant commissioner has been activated by the respondents 4 to 6 by filing an appeal. Kindly see that.
On the ground that?
They have purchased, one Ganeshappa Koppad purchased the disputed land which was subject matter of long drawn litigation on 13/6/2011.
Where is the sale deed?
13/6/2011.
Sale deed ಅಲ್ಲಿ?
Sale deed now produce madilla. That is the subject matter of
Annexure R1 along with my statement of
There is
objection.
a sale deed.
Yes, ma'am.
Yes.
said to have been executed by Channava.
Your mother.
ಹಾ 11/2011. No mutation entry had been sought for.
Yes.
Because the status of Channava as wife of Basappa itself was under dispute. It's only in RSA she was held to be the wife of Basappa, and consequently appeal was allowed.
The status was only confirmed. Ashte. The status was there from the date of marriage. It's only a confirmation.
ಅಲ್ಲ ಮೊದಲು ನಮ್ಗೆ ಅಗೇನ್ಸ್ಟ್ ಆಗೋಗಿ
You are the adoptive son.
ಅಲ್ಲ ಅಡಾಪ್ಟೆಡ್ ಸನ್ ಆಮೇಲೆ ಸ್ಟೇಟಸ್ ಆಫ್ ಹಿಸ್ ಅಡಾಪ್ಟೆಡ್
Are you
ಮದರ್.
questioning your mother's marriage?
ಹೌದು.
You are questioning your mother's marriage.
No, I am not questioning the adversary in the civil suit.
He had questioned.
Questioned
Are you
it.
questioning?
I have not questioned. I cannot question because my existence
But
is
in
on the.
dispute ಅಂತ ಹೆಂಗ್ ಹೇಳ್ತೀರಾ ನೀವು?
ಅಲ್ಲಲ್ಲ, dispute in that matter. It was concluded. If she had no title, if it was pending in civil suit, RA and RSA.
Trial court had passed an order dismissing the suit.
Yes.
So the dispute came to an end.
Yes.
First appellate court reversed the order.
Yes.
RSA reversed the first appellate court
Please,
order. So as on 2011, when RA was pending,
yes,
you are contending that this one was in dispute.
Throughout it was in appeal, and finally
That
it
is
was.
for them to say. You can never say that. You are stepping into our shoes.
Sorry, my lord,
That's not the argument available for you.
ಈ ಡಿಸ್ಪ್ಯೂಟ್ಗೋಸ್ಕರ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. 2011 ನಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಚನ್ನವಾನೇ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ದಿ ಕಂಟೆನ್ಷನ್ ಆಫ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ 4 to 6 years.
Yes.
Which is not admitted. It is false.
By whom?
By us.
Who are you to admit? He has executed the sale deed.
ಅಲ್ಲಲ್ಲ, ಸೇಲ್ ಡೀಡ್
Registered sale deed.
ರಿಜಿಸ್ಟರ್ಡ್ ಸೇಲ್ ಡೀಡ್ ಆದಾಕ್ಷಣಕ್ಕೆ ಅದು ಸುಳ್ಳು.
PG signatory ಮೇಲೆ.
ಅಲ್ಲ, ನಾನ್ ಚಾಲೆಂಜ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಬರುವುದಿಲ್ಲ. ದೇ ಡಿಡ್ ನಾಟ್ 2011 ನಲ್ಲಿ ದೇ ಟುಕ್ ಎ ಸೇಲ್ ಡೀಡ್. No mutation entry was got made.
ಆಯ್ತು.
They did not approach the Tahsildar as required under law.
Yes. That's a revenue entry not carried out.
They have Channava ಹೆಸರಿತ್ತು, ನನ್ನ ಹೆಸರು IS seal ಬಂತು. IHC proceedings only, they were not parties.
Yes.
They were not aggrieved of my entry because they are not parties to it. When it was made in my name on 23, their remedy was elsewhere. They could not have filed an appeal before the assistant commissioner. It is for this reason, my lords, 128, 129, order alive, to prefer an appeal.
Yes.
Wife and children of Ganesh Koppat, Yalla Koppat family is a dispute.
In page 128. 128 illa page. Section.
Yes, ma'am.
Section.
Land Revenue Act.
One 128 proceedings Sagilla.
ಆಯ್ತು.
129 ನಲ್ಲಿ registration of mutation and register of disputed cases. The prescribed officer, kindly see my lord, prescribed officer under the statute is only Tahsildar. Shall enter in the register of mutations every report made to him under subsection 1 of section 128 or received by him under subsection 2 or subsection 4 of the said section. Wherever a prescribed officer makes an entry in the register of mutations, he shall at the same time post a complete copy of the entry in so-and-so. So, authorized prescribed officer is Tahsildar alone.
Have you challenged the sale deed?
That stage did not come at all. We are in revenue proceedings now.
You are not challenging the sale deed.
I have not.
Very good.
He is signatory of the sale deed.
Even better.
Alalala. It is all fake sale deed which they have set up. They had slept over the matter for 12 years of the alleged sale deed. They have taken advantage of the helplessness, illiteracy and ignorance of the old lady. That apart, now I am challenging the order of the assistant commissioner. I am aggrieved of that.
Yes.
Whereas the appellant therein, who are respondents 4 to 6, were not aggrieved of that order because they were not parties to the proceedings of IHC made in my name from the name of my mother.
Yes.
Aggrieved hengagtar avaru?
Chance illa. Alla.
No, they cannot be. If they are aggrieved, they have to approach the prescribed authority.
Yes.
If the Tahsildar had refused their prayer, then they are aggrieved. They can go before the assistant commissioner. Assistant commissioner is not the original authority. He is only appellate authority. There was no order of which the respondents 4 to 6 were aggrieved.
IHC was entered by
Tahsildar. IHC proceedings, they are not parties.
Yes.
They are not approached the officer concerned to make mutation entry in their name immediately after purchase of the sale deed or subsequent thereto. It's only when Tahsildar makes an IHC entry in my name, they prefer an appeal, which is impermissible. Kindly come to 136. It is question of jurisdiction. Appeal and revision. The provisions of chapter 5 shall not apply to any decision or order under this chapter. Any person affected by an order made under subsection 4 or an entry certified under subsection 6 of section 129 may prefer an appeal before the assistant commissioner. He was not a party to the original order.
Yes.
Therefore, the order impugned has to go for want of jurisdiction, no authority, for the simple reason that there was no appealable order in which the appellants therein were aggrieved. It is not their case. If their case is that he had no right to get the IHC entry, he was not the adopted son of Channava. That is not their case. Simple order, mutation tree in my name is that my mother is dead. She has adopted me. She has executed a will. And I have inherited it. That they cannot dispute. They will not dispute.
Yes, yes, madam.
Please, madam. The original propositor is Basappa, my lord. He died in the year 1988, 15/3/1988, my lord. And they claims through will executed by Basappa in the year 1988 itself, my lord. But it is not proved in the RSA. During the pendency of the RSA, my lord, in the
You have taken
RSA,
a sale from her. How can you question that?
please, my lord.
You are she is your vendor.
No, I am
You're disputing the will even now.
No, the thing is, my lord, even it is attained finality before the Supreme Court. Will is not proved, adoption is not proved, and
Supreme Court go get
yes, my lord.
Where is the Supreme Court order?
Annexure, Annexure R2.
R2.
Please.
We had no notice of such.
We do not find any ground to interfere with the impugned order passed by the High Court.
Yes.
RSA is confirmed.
RSA is confirmed. Will is not proved.
So there is no
adoption.
reasoning.
Yes.
It's a confirmation.
I am the purchaser from Channava.
Yes.
Channava. She is executed in the year 2011. That is said it 13/7/2011.
13/6/2011.
Yes, sir. In that said it, my lord, your lordship kindly come to page number 13.
13 of?
13 of my statement of objection. Annexure R1. Annexure R1. Registered said it, my lord.
Yes.
It is executed in the name of my husband, my lord. The said it. And ಸಾಕ್ಷಿದಾರರು 2 ಮಂಜಪ್ಪ ಕೊಪ್ಪದ ರಾಣೆಬೆನ್ನೂರು.
ಎಲ್ಲರೂ ಕೊಪ್ಪದ್ದೇ ಯಾರು ಮಂಜಪ್ಪ?
He is the signatory.
ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ. ಏನೋ ರಿಪ್ಲೈ ಇದ್ರೆ ಹೇಳಿ, ಮಧ್ಯದಲ್ಲಿ ಹೇಳ್ಬೇಡಿ.
Yes. Through register said it, my lord, I have purchased the land. After death of my husband, my lord, our names are entered in the record of rights. So I am the absolute owner of the property. Therefore, my lord, the impugned order rightly passed by the assistant commissioner as well as the deputy commissioner confirming I am the owner through register said it. But what happened, my lord? During the pendency of the appeal, my lord, Channava died
in RSA.
Taking advantage of that, my lord, he entered his name in the record of rights. Only in the cause title of the RSA, he claims to legal heirs of the Channava. On that basis only, my lord, page number 44, my lord, annexure H. Manjappa Basappa Koppad.
You are the wife of Ganeshappa Koppad.
Yes,
Who
my
is
lord.
Basappa Channappa Koppad?
He is a husband, brother, relative, son.
Husband's brother's relative's son.
Yes, my lord. He is He is relative.
Okay, yes.
Andre Basappan relative. Bas. Please, please, my lord. Your lordship.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂತೀರಾ ಹೇಳಿ ಅಷ್ಟೇ, ಆಗಲ್ಲ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಎಸ್.
During the pendency of the appeal, my lord, taking advantage of the death of Channava, my lord, enter the name of the
IHC.
only on that basis, my lord. That is question under the 136(2) and 136(3), my lord. Under section 128, my lord, my name is to be entered as per the register sale deed.
Form J was sent. Form J ಕಳ್ಸಿದ್ರ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್?
Yes, my lord.
Where is Form J?
ಇಲ್ಲ.
Page number 18, my lord.
ಏನು ಜೇನಾ?
J, ಎಮ್ಮಿ ಇದೆ ಇಲ್ಲ? ಎಮ್ಮಿ ಇದೆ.
ಎಮ್ಮಿ ಅಲ್ಲಮ್ಮ. ಸಾಹೇಬರು ಕೇಳಿದ್ದು ಎಮ್ಮಿ ಅಲ್ಲ.
No Form J was sent.
R3 and R4.
Yes, any reply?
Lord, kindly take annexure D in page 27.
Yes.
The order of the assistant commissioner, which I am attacking on the ground that he had no jurisdiction. He decides the title and ownership. ಮೇಲ್ಮನವಿದಾರರು ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಕಾಯ್ದೆ 64 ಕಲಂ 136/2 ಕೆಳಗೆ ರಾಣೆಬೆನ್ನೂರು ತಾಲೂಕು ರಾಣೆಬೆನ್ನೂರು ಗ್ರಾಮದ ಹಕ್ಕು ದಾಖಲಾತಿ ಸೋನ್ಸೋ ವಿರುದ್ಧ CM ನಾರಜ್ಜಿ ನ್ಯಾಯವಾದಿಗಳು ರಾಣೆಬೆನ್ನೂರ ಇವರ ಮುಖಾಂತರ ಈ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಒಂದು ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. Impugned order is IHC. My lord, I am at the cost of repetition, I am repeating. IHC, in which there was no other person involved, which is not an appealable order. ಮೇಲ್ಮನವಿದಾರ ಸಲ್ಲಿಸಿದ ಮನವಿಯೊಂದಿಗೆ ಸಲ್ಲಿಸಿದ ಕಾಲ ವಿಳಂಬ ಮನ್ನಾ ಅರ್ಜಿಯನ್ನು ಅಂಗೀಕರಿಸಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ವಿಚಾರಣೆಗೆ ತೆಗೆದುಕೊಳ್ಳಲಾಯಿತು. After 12 years, he claims right, and in one line, without saying anything, Assistant Commissioner says, delay is condoned and matter is taken on. ತಂಟೆದ ಆಸ್ತಿಯ ಕುರಿತು 1ನೇ ಮೇಲ್ಮನವಿದಾರರ ಗಂಡ 2 ಮತ್ತು 3ನೇ ಮೇಲ್ಮನವಿದಾರರ ತಂದೆಯು ಎದುರುಗಾರನ ತಾಯಿಯಾದ ಚೆನ್ನವ್ವ ಬಸಪ್ಪ ಕೊಪ್ಪದ ಇವರು 13/6/2011 ರಂದು ಮೇಲ್ಮನವಿದಾರರ ಗಂಡ ಅಂದರೆ ಪೋತಿ ಗಣೇಶಪ್ಪ ತಂದೆ ಮಹದೇವ ಕೊಪ್ಪದ ಇವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ ಪತ್ರದ ಪ್ರಕಾರ ನೋಂದ ಮಾಡಿಸಿಕೊಟ್ಟಿರುತ್ತಾರೆ. ಸದರಿ ಖರೀದಿ ವ್ಯವಹಾರವು 1ನೇ ಎದುರುದಾರರಿಗೆ ಗೊತ್ತಿರುವ ವಿಷಯವಾಗಿರುತ್ತದೆ. ಆದರೂ ಸದರಿ ಎದುರುಗಾರರು ತಾಯಿಯಾದ ಚೆನ್ನವ್ವ ಇವರ ಪೋತಿಯಾಗಿರುತ್ತಾರೆ. ಸದರಿ ಪೋತಿಗೆ
ರಿಪ್ಲೈ ಯು ಆರ್ ರೀಡಿಂಗ್ ದ ಆರ್ಡರ್ ನೌ. ರಿಪ್ಲೈ ಅಲ್ಲಿ ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ.
ಅಲ್ಲ, ರಿಪ್ಲೈನೇ ಇದು.
ರಿಪ್ಲೈ ಮತ್ತೆ ಆರ್ಡರ್ ಓದದ?
ಅಲ್ಲ, ಆರ್ಡರ್ ತಮ್ಮ ಗಮನಕ್ಕೆ ಬಂದಿಲ್ಲ. My lords will take decision only after my lords know the illegality and arbitrariness involved.
You already argued that.
Yes. Kindly see.
Can you read the order in the reply?
In page 28, in page, kindly come to bottom 9 lines.
Reply ಏನಾದ್ರು ಇದ್ರೆ ಹೇಳಿ.
ಅದು ರಿಪ್ಲೈ ಒಳಗೆ ಆಕ್ಚುಯಲ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಬೇಕಾಗತ್ತೆ. ಸದರ ಪೋತಿಗೆ ವಾರಸುದಾರರು ಅಂತ ಎದುರುದಾರರು ದಾಖಲು ಮಾಡಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಆದರೆ ಸದರಿ ಚೆನ್ನವ್ವ ಇವರು ಪೋತಿಯ ಪೂರ್ವದಲ್ಲಿ 1ನೇ ಮೇಲ್ಮನವಿದಾರರ ಗಂಡ ಅಂದರೆ ಗಣೇಶಪ್ಪ ಇವರಿಗೆ ನೋಂದಾಯಿತ ಖರೀದಿ ಪತ್ರದ ಪ್ರಕಾರ ಖರೀದಿಗೆ ಕೊಟ್ಟಿರುತ್ತಾರೆ. He concludes without considering the fact that there is no appealable order before him.
Yes.
I am reading Assistant Commissioner's order.
ಹೇಳಿದೀರಾ ನೀವು?
Therefore,
no power to exercise appellate powers under 136(3).
The dispute, we have categorically denied that there was such a sale deed executed by Channava. And there was no sale deed at all. Which matter ought to be decided after recording evidence by a civil court. It is not for Assistant Commissioner sitting as an appellate authority to decide, which was not subject matter This sale deed was not subject matter of the IHC proceedings. For the first time, on appellate side, this is taken up and held that there is a sale deed. Therefore, kindly see, there is a direction to the Tahsildar to mutate the name of these appellants before the assistant commissioner, for which he has no jurisdiction. This proceeding is confined only to the extent of jurisdiction of AC to have dealt with a matter which was not subject matter of the original order before the prescribed authority. Therefore, the assistant commissioner's order and
so and so reserved.
citations in this regard.
We don't need to tell you this. You did not rely on anything during your argument. ಆಮೇಲೆ order ಓದ್ತೀರಾ, ಇವಾಗ reply ಆದ್ಮೇಲೆ citations ಕೊಡ್ತೀನಿ.
Only to say it is not for them to decide.
This is not a proper thing. If you wanted to rely on his citation, you should have produced it, relied upon it during your arguments, furnishing a copy to the other side. Our reply ಆದ್ಮೇಲೆ citation ಅಂತ. Please, this is not a message that you are conveying it rightly to this one. Kodi, citations kodi.
I'll furnish copy to them also.
Not proper.
I'll make available with them. I'm sorry.
Make available ಅಲ್ಲ. ಇವಾಗಲಾದ್ರೂ ಹೇಳಿ citation so that if they need they can reply.
Blood, our kೈ ಕುಡಿ ಒಂದು. Okay. ಆಮೇಲೆ ಶಿವಣ್ಣ ಇನ್ನೊಂದು ಎಲ್ಲ ಇನ್ನೊಂದಾಗಿ.
Yes, para.
ಒಂದು ನಿಮಿಷ. ರಂಗವಿಟ್ಲಾಚಾರ ಫುಲ್ ಪೇಜ್. LK Jain. First case I cited, I'm relaying it. Shivanna versus Special Tahsildar and others, dealt by His Lordship Justice D.V. Shailendra Kumar.
Yes.
I would not be troubling my lords by reading everything. I will only read last paragraph 19.
Yes.
There was also delay in approaching the original authority itself. In fact, even in respect of immovable properties, a period of 12 years is sufficient even for a stranger to perfect his title. And if so, it is not the business of revenue authorities to act under a sale deed of the year 1924 for recognizing a right under this sale deed of the year 1924 in the year 2001. Definitely much water has flown under the bridge in between these years. It is for this reason I am holding that the order passed by the Tahsildar is not legal and without jurisdiction, and it calls for interference. There the Tahsildar himself had made such an entry, which was quashed by the Honorable High Court, directing the parties to.
Yes.
And when the next full bench decision, ILR 2002, Karnataka 2750. I will only read conclusions. Only para 9 minutes, which would be relevant.
Yes.
Considering Rule 43, when a person claims title to a property under a will for the purpose of getting a mutation entry in the revenue records, before any such entry is made, the revenue code should prima facie be satisfied that the said document is genuine and valid, even in the absence of any dispute, as the said will comes in the way of natural succession. By virtue of section 128, when the owner of the land dies, the title to the said property passed on to the legal heir by succession or survivorship or inheritance, and the property vests with such a legal heir without there being any document, and purely based on the relationship of the deceased with the legal heir. A will can come into operation only after the death of the executant. If a will is set up to to deprive a legal heir who had acquired title to the property either by succession, survivorship, or inheritance, the person claiming under the will has to show better title. If the will is disputed, strict proof of so-and-so is to be provided. When the revenue court is prevented from recording the statement of the parties and the depositions, the question of establishing the genuineness of the will for any purpose whatsoever before the revenue court in an inquiry would not arise. Under these circumstances, the revenue courts have no jurisdiction to go into the genuineness or validity of the will or the question of title in respect of the land in dispute. The decision of revenue court has to be necessarily based on the undisputed facts. The revenue court cannot go into the disputed questions of relationship, status of the parties, title to the property, or genuineness or otherwise of a document, or challenge to the documents on the ground of fraud, undue influence, misrepresentation, or mistake. As such, the petitioner cannot take advantage of Rule 23 in the case of 43 in this case. The appellate authority before whom the sale deed was produced, we have said no, there is no such sale deed, it's all fake. He decides, sale deed is there. Genuineness he accepts. He had no authority to do that.
Yes. Reserve.
26, HM Dharwad.
Petitioner. My submission is, there is way to shift the agriculture, but the crops by sought for interim order. But subsequent report also the made by the Tahsildar with the same.
There is no interim order you sought for.
Find application the.
To close the illegal trench.
Please.
Mandatory, we'll have to hear.
The last hearing date, the Honorable Court has directed the respondent to secure the records in respect of map which has been produced by the respondent 7 to 8.
Subsequent report also the same things Annexure J.
As per the subsequent report, I don't any objection. Very prakar or use ಮಾಡ್ತಾರೆ. Even my objection, may kindly see my objection.
Yes.
I have not received any instruction. It will take next week, Your Lordship.
Yaar kodbek instructions, sir?
Tahsildar, Your Lordship.
Tahsildar.
And Your Lordship, as per annexure, Your Lordship, submitted by the respond council.
Respond number 4 kodbeka. And AGA submit that is it to secure instructions. If instructions are not secured by 7th, respond number 4 shall be personally present before this court on 11th.
7th or 11th present.
27 adjourned, 28.
27 could notice could. Petition could, alias could.
1 to 4, I accept notice.
1 to 4. Huh?
Yes.
And AGA accepts notice for respond number 1 to 4. Issue. Your 5 to 12 are the parties in the other matter?
ಅಲ್ಲ ಅದರಲ್ಲಿ ಒಬ್ಬರೇ ಇದ್ರು. ಹನುಮಂತಪ್ಪ ಅಂತ was the only private party in that case.
So notice has to go to them.
Yes, my lord.
Issue notice to respond number 5 to 12, returnable by 19th March.
Please.
CR Hiremat.
Petitioner, my lord, is the person who has entered into the agreement of sale.
No interim relief is sought.
Lord.
And AGA accepts Tahsildar, accepts notice for respond number 1 to 3. Seeks for and is granted 10 days time to obtain instruction, make a submission. Released on 13th.
29 Shuraj.
Paso.
They are seeking a writ of mandamus. Notice has to mandamus ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Interim order ಏನಿಲ್ಲ.
ಇಲ್ಲ.
And AGA accepts notice
for 1 to
respond number
1 to 3.
1 to 3.
Please.
CM's,
TMC
Kukkeri.
Okay.
Please, so and so is directed to accept notice for respond number 4, issue notice to respond number 5 to 7, returnable by 12th March.
30, NP Vivek Mehta.
My lord, the petitioners are defendants. Suit is for partition.
Defendants.
Please, my lord.
Yes.
Suit is for partition and separate possession. Case of the defendants is that, my lord, their mother has relinquished the suit properties in favor of the present petitioners. And she also moved an application to enter their name, petitioner's name, in lieu of her relinquishment deed. They moved an application to call that application which has been produced before the Panchayat Development Officer to verify the signature on it. That application has been rejected by the tribe.
Original document has to be produced.
Original.
Issue notice to the respondent, returnable by 18th March. The further proceedings in OS number 231 of 2018 pending on the file of the additional senior civil judge in JMFC Haveri. He stayed till the next date of hearing. Process fee and copies to be furnished by end of day 4th February. Acknowledgement service of notice on the counsel for the respondent before the trial court to be filed by end of day 7th February. Failing either of which, the interim order will stand automatically vacated.
31, DB Pattar.
Appear for the petitioner in this matter, my lords. My lord, late husband of the petitioner, he was the purchaser of the property in question, my lords. He has purchased the property in question from the mother of the respondent number 5, my lords. After demise of petitioner's husband, my lord, she moved application to Tahsildar, my lords. Tahsildar, my lords, abruptly, my lords, on only ground that, my lord, the civil suit is pending, my lords, was to deny her right to mutate the her name in the property, my lords.
What is the civil suit for?
Suit for, my lord, one of the brother of the respondent number 5, my lord, filed a partition suit 1/5 share, my lords. After sale of the property in question, and my lords, the mutation was effected in the name of the husband of the petitioner, my lord. Subsequent to that, the suit has been filed, my lords. And
Sale
more.
deed was in 21.
Yes, please, your lordship.
Suit was?
Suit has made a partition and separate possession, my lords.
Subsequently.
Lords.
Issue notice, Lord AGA accepts notice for respond number 1 to 4. Issue notice to respond number 5, returnable by 19th March. Respond number 5 is restrained from interfering with the possession of the petitioner, as also from any manner alienating, encumbering, or dealing with the suit scheduled property till the next date of hearing.
Please, your lordship, oblige.
And copies by 4th February. Acknowledgement of service on the counsel for respondent number 5 before the trial court to be filed on or before 7th, failing either of which.
Please, your lordship, oblige.
32, Santosh Rao.
I am appearing for petitioner, my lordship. Nature of certiorari, my lordship.
Yes. Really?
Originally, land belongs to government, my lord. Survey number 237, 33 acres, 4 guntas, my lordship. On 15/1/1997. The land has been granted to my father by the government. Thereafter, accordingly, our names were entered, and after the demise of petitioner's father, came to be my name came to be recorded, my lordship. Thereafter, father filed application before their Tahsildar, relaxation of condition which has been instead of grant order, that condition have instead to been relaxed.
Yav condition, no?
8/10/2015, my lordship.
Page?
10/2015.
Page?
Tahsildar Atni has been.
In grant condition,
Annexure C, my lordship.
Annexure B.
Page number.
Page number 12, my lordship. Annexure A.
Annexure A. Yes. Yav condition violate aitu andru?
4.
ಮೋಜನಿ ಮಾಡಿಸಿ ಅಂತ.
ಮಂಜೂರಾದ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ಮಂಜೂರಾದ ಜಮೀನನ್ನು 15 ವರ್ಷಗಳವರೆಗೆ ಪರವಾರೆ ಮಾಡೋದು.
ಪರಭಾರ ಮಾಡೋದು. ಈ story is still holding it.
No. Your lordship, the annexure F, your lordship, in the impugned order, in page 28, your lordship,
In
Second
page?
para, 28, Your Lordship.
And F.
Second para, Your Lordship. 28 ದಲ್ಲಿ. Page number 28, second para. ತಹಸೀಲ್ದಾರ್ ಕಾಗವಾಡಿ ಅವರು ವರದಿ ನಂಬರ್ LND-CR 2821 ದಿನಾಂಕ 19/4/2020 ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ವರದಿಯಲ್ಲಿ ಐನಾಪುರ ಪಟ್ಟಣ ಸರ್ವೆ ನಂಬರ್ 230 ಕುರಿತು ಸ್ಥಳ ತನಿಖೆ ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು, ವರದಿಯಲ್ಲಿ ಪುತಳಾಬಾಯಿ ಅಡ್ವೇಸ್ ಭೂಮಿ ಇವರ ಮಂಜೂರಾದ ಜಮೀನಿನ ಸರ್ವೆ ನಂಬರ್ 237 ರಲ್ಲಿ 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು 15 ವರ್ಷಗಳ ಷರತ್ತು ಮುಕ್ತಾಯ ಪೂರ್ವದಲ್ಲೇ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ.
ಎಲ್ಲಿ ಮಾರಾಟ ಮಾಡಿದ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನ್ ರೆಫರೆನ್ಸ್?
It is the finding report submitted by the Your Lordship.
There is a document for that. We must say which sale deed, what is the date of the sale deed, registration. And the petitioner only is for this court.
That is there, Your Lordship, but it is a report, Your Lordship, as per that.
Sale ಮಾಡಿದ್ರೆ ಅವ್ರೇನಕ್ಕೆ ಬರ್ತಾ ಇದ್ರು?
I'll file objections.
File objection and AGA accepts notice for respond number 1 to 4, issue notice to respond number 5 to 6 written by 26th March. The operation of the order dated 15/2/24 passed by respond number 2 at annexure G, and the order dated 8/8/2022 passed by the respond number 3 at annexure F is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 4th February, failing which the interim order will stand automatically vacated.
33 Anand Kolli, please.
Yes. Without making me before the party, before the trial court, though I being a member of the joint family, my brothers and sisters had restricted their property and filed a compromise petition.
Hanumappa, son of Durgappa.
Yes, boss.
Alias son of Durgappa.
Yes. Genealogy I showed my lords at page number 6 in my petition. The genealogy that they have shown in page number 18 to show that I am the member of the joint family. Page number 37.
37.
Yes, miss. Nagappa, Kankappa, Hanamappa and Lalita, all are my brothers and sisters.
Nagappa, Tande Durgappa.
Yes.
Sanna Durgappa.
This property was left out.
Hanumappa, 3 ಎಕರೆ. ಹನುಮಪ್ಪನ ಹೆಸರಲ್ಲೂ 3 ಎಕರೆ ಆಗಿದೆ.
ಅಲ್ಲಲ್ಲ. This property was left out, not at all included.
This is not part of
not a partitions.
Issue notice to respond number 1 to 8, returnable by 26th March. The operation of the compromise decree passed by the permanent local Adit in OS number 266 of 2018, which was pending before the senior civil judge Kustagi, dated 9/3/2019 at annexure C, is stayed till the next date of hearing. The respondents are restrained from any manner dealing with, alienating, encumbering the suit scheduled property or any part thereof till the next date of hearing.
Please.
Process fee and copies to be furnished by end of day 4th February, failing which interim order will stand out.
Please. Obliged.
34 CR Hiremat.
I'm challenging the Millard, the action on the part of the Millard CMC. That though Millard, they have issued the notice as per Millard's annexure L. That's it's page number 151. I have answered Millard's the entire Millard's things which has been Millard's in the notice. They have stated allegedly Millard's they have stated that Millard's I have encroached some lands. That's as per annexure A Millard's I have answered. Since Millard that land itself is not Millard's within the purview of the Millard's CMC, there is no question of issuance of the annexure A Millard kindly may annexure A.
Not within the territorial limits of the CMC.
Please, because Millard's
They are limits al barata.
no, the brief facts are Millard's. While Millard's the petitioner in the year Millard's 2000 in 1983, he was Millard's assigned a land of Millard's the plot of 15 and 16 by the Millard's the assignment deed as per Millard's annexure C. That is Millard's subsisting in the Millard's letter. He is in possession of those lands. Now Millard's the CMC was issued the notice that issuance of Millard's plots has been questioned by Millard's.
It doesn't come in CMC jurisdiction. In whose jurisdiction would it come?
It is totally Millard's private land. It is under the dispute.
ಅದು ಬೇರೆ. That
Please.
is something which they'll determine. Territorial limits al bharat tane CMC.
May I take
Property CMC territorial limits al
page,
bharat.
this factum of allotment has been challenged by the one of the owner in the survey number 214 and 5, that is annexure B, page number 15. Wherein one Kishan Rao has challenged the my assignment, that is plot number 15. The government is also party to that.
You submitted a reply that has not been considered.
Please.
That's the only thing.
Please. And thereafter annexure L has been issued.
Your relief is very innocuous. Learned AG accepts notice for respond number 1. Please. CMC Gangavati.
Sharon Basu. B. Sharon Basu.
B. Sharon.
B. Sharon Basu.
P. Sharan Basava is directed to accept notice for respond number 2. Petitioner is before this court seeking for the following leaves. The grievance of the petitioner is though the petitioner has replied to the notice issued by respond number 2 on 25/9/2024. The said reply has not yet been considered, and as such, there is a possibility of an order being passed by respond number 2 without such consideration. Whenever any notice is issued and a reply submitted thereto, it would be required of any authority, including the respond number 2, to consider the same and pass necessary orders in accordance with law. The apprehension on part of petitioner is ill-founded. Be that as it may, respond number 2 is directed to consider the reply of the petitioner dated 30/9/2024 issued to the notice dated 25/9/2024 and thereafter pass necessary orders in accordance with law.
Please.
35, Sadiq.
Entries without notice. Entries without notice, your lordship.
Wakaf.
Yes.
And AGA accepts notice for respond number 1 to 4. Shri
B. Mohammed.
B. Mohammed Ali is directed to accept notice for respond number 5. Wakaf, same order.
In this manner, earlier two, your lordship has disposed, it was with respect to column number 11. In this manner, line 11 and 12.
Column number 9.
11 and 12.
9, 11 and 12 restore madbeka.
Out.
Where is that order? Where is the RTC?
RTC annexure A.
CMC hospital. Operative portion on separate ಆಗಿ ಮಾಡ್ಕೊಳ್ಳಿ. To delete the name of respond number 5 in column number 9. 11 ಅಲ್ಲಿ ಏನಿಲ್ವಲ್ಲ?
11 ಅಲ್ಲಿ 12 ಅಲ್ಲಿ ಇದೆ.
9 and 12.
Please.
And restore the name of the petitioner in column number 9 and 11, 9 and 12.
11 ಅಲ್ಲೂ ಇದೆ.
11 ಖಾಲಿ ಇದೆ.
B ದಲ್ಲಿ ಇದೆ.
ಖಾಲಿ ಇದೆ. ನಿಮ್ಮ ಹತ್ರ ಬೇರೆ ನಮ್ಮ ಹತ್ರ ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
B ಅಲ್ಲಿ.
Annexure A ಅಂದ್ರೆ.
B ಅಲ್ಲಿ. 11 ಅಲ್ಲೂ ಇದೆ.
9, 11 and 12 and restore the name of the petitioner within a period of 30 days from date of receipt of copy. IA1 doesn't serve it.
36, Roshan Chabbi.
They are challenging the endorsement passed by second respondent. The petitioner is a partnership firm engaged in the business of development, my lord, registered under RERA. The petitioner purchased the land, my lord, and sought permission from the CMC, second respondent, which they gave permission, and sanction plan was also approved. As per the sanction plan, my lord, they started carry out the construction. And my lord, also paid taxes regularly. Now suddenly, out of nowhere, my lord, the third person comes to and files the complaint saying that an inspection has to be carried out with the concerned construction. On his behest, my lord, respondent to inspects the property and endorse, my lord, at annexure F, saying that all construction is as per the sanction plan and with the permission. The detailed technical report is at annexure F1, my lord. It says, my lord, at page number 56, the relevant portion, all the parameters taken, my lord, in access to the setback rules. ಎಷ್ಟು ಬಿಡಬೇಕಾಗಿತ್ತು ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿನೇ ಬಿಟ್ಟಿದ್ವಿ.
Notice was issued under 187.
Please.
2.58, 2.5. ಸ್ಥಳಕ್ಕೆ ತನಿಖೆ ಮುಂಭಾಗನು 13.97. ಏನು ಸೆಲ್ಲರ್ ಇಲ್ವಾ ಪರ್ಮಿಷನ್?
ಅಲ್ಲ, ದಿಸ್ ಪರ್ಮಿಷನ್ ಇದೆ my lord. Now what he says is inspection ಸರಿಯಾಗಿ ಆಗಿಲ್ಲ. He does not trust the department itself. And second representation my lord, he says that some independent inspector has to come and inspect the construction my lord. And on that basis my lord, then again an endorsement at an extra G.
ಯಾರು ನಗರಸಭೆ ಹೊಸಪೇಟೆ?
Lords, I accept notice for respondent number 2, municipality.
Lord AG accepts notice for respondent number 1. Shri so-and-so accepts notice for respondent. How are you issuing this kind of a?
As per my oral instructions, my lords, earlier inquiry was conducted in presence of executive engineer. At annexure F, my lords, seeing page 47. Lords, the report says, my lords, that there is no violation, my lord, in respect of building bylaws.
Yes.
Again, my lords, at the instance of D. Venugopal, he has raised the objection on the technical report, which is at annexure F1. Lord, pursuant to that, my lord, the respondent number 2 has issued, my lords, this notice, my lord.
Just because a complaint is received, you can't stop unless you find out that there is
report is
any construction. You will make good the losses which will be caused. ಹೇಳಂಗಿದ್ರೆ ಹೇಳಿ, ನಿಮ್ಮ commissioner will deduct his salary for that.
Now, the F1, my lord, technical report is done in the presence of the executive engineer. Now, my lord, they have raised the objection on this technical report. My lords, now they have...
That objection will have to be made good.
Please.
Until then, you can't say stop.
No, my lord, they've issued, my lord, annexure G, my lord, the notice to asking them to be present, my lord, in presence of third person.
This is only for one reason. Nothing else. How many times will you cause the inspection? We'll direct the inspection of your commissioner's house to see if it is constructed in accordance with law.
That cannot be done.
Marana? Once a inspection has been carried out by a team,
please,
and the report has been given, somebody gives a
instance.
complaint and you stop the construction. The operation of so and so at annexure G is stayed till the next date of hearing. An affidavit to be filed by respondent number 2 as to on what basis annexure G has been issued. When there is a report already on record that the construction which has been carried out, including the setbacks, is in terms of the sanctioned plan. Relist on.
Lord, we are also seeking stay of that annexure G.
Stay ಆಯ್ತಪ್ಪ. Stay ಆಯ್ತು ಇವಾಗ ಆಕ್ಷನ್ ಅಷ್ಟೇ. Relist on 13th. ನಾವು ಇಲ್ಲಿ ಆಕ್ಷನ್ ತಗೊಂಡ್ರೆ ಅವ್ರು ಮತ್ತೆ ನಿಮ್ಮ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಂಡ್ರೆ ಅದಕ್ಕೆ ಸುಮ್ಮನೆ ಇರೋದು, ಬಟ್ ತಗೊಳ್ಬೇಕಾಗತ್ತೆ. 13th.
Please.
Please.
Serial number 13. ತಗೊಳ್ಳಿ.
List 2, serial number 13. Girish Bhatt.
Please, my lord, this matter relating to the appointment of library supervisor under Gram Panchayat.
What is the urgency?
My lord, by annexure G, page number 21, 22, the petitioner name was selected in the first provisional list. The precondition is that, my lord, the applicant should be from the same village to which the appointment is going to be happen. So, my lord, the petitioner name is at column number
page
23, my lords, relevant portion, page 23.
Yes.
Page 23, column number 10. Column number 10, my lords, the fourth column, ನೀವು ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಯೇ ಹೌದು. So petitioner was the native of the locality, the sir ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಂಜಲಿ. Column number 10.
Row, ಅಲ್ಲ ನಿಮ್ಮ ಹೆಸರು column number 10, row 10.
Kaveri. Petitioner is Kaveri.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿದೆ ಅಂಜಲಿ ಅಂತಿದೆ.
ಅಂಜಲಿ, ಹಾ.
Petitioner is Kaveri.
Kaveri petition is Kaveri.
Kaveri is 14.
Sorry, Malad, there was 4 petitions. Like confused ಆಯ್ತು ಅದಕ್ಕೆ.
Cell number 14.
14 Malad.
14. Row 14.
ಹಾ, ಕಾವೇರಿ. ಅದರಲ್ಲಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿ ಒಳಗೆ 1 2 3 ಹೌದು ಅಂತ ಹೇಳಿ ಇದೆ. ಸಾರಿ Malad.
ಅಭ್ಯರ್ಥಿ ಎಲ್ಲಿದೆ?
5th row, ನೀವು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿಯೇ.
Yes.
Answer is yes, Malad. Now may I take Malad to the second provisional list, page number 27. Column number 14, my lord. The 7th respondent. Nagaveni. 5th row, ನೀವು ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸ್ಥಳೀಯ ಅಭ್ಯರ್ಥಿ? No, ಇಲ್ಲ. So without any reasons, when the first provisional list was published, I was the qualified and my name was reflected. Immediately, my lord, they published a second provisional list. My name was removed. I have not been informed as to why my name has been removed.
Why you include all the people who are not residing?
My lord?
Cell number 9 illa, 10, 11, 12, 13, 14.
Other 3 matters, my lord, this one I'm going to grant the stay.
You only selected people who are not residing.
Stay similarly.
Officer thinks only people not residing have to be
For
selected.
instructions, your lordship.
Notice ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ ಇದ್ರೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಅಂತ ಹೇಳಿ.
AGA accepts notice for respond number
1 and 6.
1 and 6. ZP Bellary?
ಇವರು ಶಿವರಾಜ್ ಹಿರೇಮಠ ಇದ್ದಾರೆ. 2, 3, 4 and 5.
2, 3, 4, 5. Issue notice to respond number 7, returnable by 7/2 ಅಂತಿದೆ. Emergent notice returnable by 7/2. Counsel for the petitioner is also permitted to take out handsomens on respond number 7 in view of the order passed in WP number 100568 of 2025 dated 29/1/2025, which should be equally applicable to the present case. The second provisional list published by second respondent dated 6/1/25 at Annexure G is stayed till the next date of hearing. Connect the above matter with WP number 100568 of 2025.
Please, my lord.
List 3, number 1, Ramchandra Malik.
Appear, my lord, for the
Yes.
petitioner. Defendant's petition, my lord. My lord, respond number 1, my lord, herein has filed a suit for partition and separate possession of, my lord, joint Hindu family ancestral properties before, my lord, trial court in OS number 80 of 2020. During the pendency, my lord, of the suit, the plaintiff started constructing a building, my lord, in a one particular suit schedule property, item number 2, that is RS number 613/B of Benadi village. That is, my lord, without permission from Gram Panchayat, without leaving any setback and encroaching upon the public road, as well as touching, my lord, the existing building of the petitioner, who is, my lord, defendant number 2. He, my lord, raised the, my lord, objection with the, my lord, the Panchayat authorities, my lord, but to no avail. The petitioner, my lord, filed an application under Order 39, Rule 1 and 2, seeking injunction, my lord, to restrain the plaintiff from putting up any illegal construction till the disposal of the suit. In spite of, my lord, grant of sufficient opportunity, my lord, plaintiff did not contest the said application before the trial court. Trial court, my lord, on the basis of the material available on its record, passed, my lord, an order in favor of the defendant, thereby restraining the plaintiff from putting up any illegal construction, my lord, on the suit scheduled property till the disposal of the suit.
Is that order?
That is Annexure D, my lord, page number
38.
34, my lord. Relevant portion, my lord, is at
38.
37, 38. May I read?
ಈ ದಾವೇಶ ಯಾವುದೇ ರೀತಿಯ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಕಟ್ಟಡ only illegal construction. You have not been restrained completely. Yes.
Now, Against this order, my lord, discretionary order passed, my lord, by the trial court, the plaintiff preferred, my lord, a miscellaneous appeal before the first appellate court, seeking setting aside the order, my lord, passed by the trial court, and requesting to, my lord, remand the matter to the trial court for giving him, my lord, an opportunity to file objections and contest the matter, my lord. Prayer is at, my lord, page number 44 in the miscellaneous appeal. Only ground was that, my lord, he has not been given sufficient opportunity, competent opportunity to contest. So only that was the, my lord, prayer before the first appellate court.
Challenging the order at page 76.
Now, the first appellate court, my lord, takes upon itself, and only on the ground that the plaintiff has put up substantial construction, it proceeds, my lord, granting the
Shall
appeal.
not claim any equities.
Now, my lord, there are certain.
If you succeed, you'll get the property.
It is not.
Filed my affidavit.
Free
also.
of cost.
I have filed my affidavit.
That is, my lord, before the first appellate court, he has done that. Now, what is, my lord, the problem for the defendant is this. This is only, my lord, 7 guntas of the property existing. And my lord, already, my lord, defendant is having his existing house in the, my lord, said property. He, my lord, without any building permit, now blanket order has been given, my lord, by the.
For the authorities to consider, you approach the authorities.
Now, what has been done, my lord, by the first appellate court is only on the basis that he has, my lord, put up the construction to some extent, my lord, it has granted, my lord, permission without any conditions as to building permissions, setbacks, anything. Even he has, my lord, encroached upon the, my lord, public road. I have produced, my lord, the photographs.
Have you approached the authorities, Mr. Malli?
That is, my lord, done, my lord. I have stated in my affidavit also, my lord, before the authorities.
We will reserve liberty for them to take any action if there's any violation.
Now, my lord, my only request is this. The order passed, my lord, by the first appellate court, my lord, is on no material and without any pleadings, because he has not contested the application, my lord, before the trial court.
That's okay.
May I request, my lord, to kindly one decision. Discretion, my lord, discretion exercised, my lord, by the trial court. In the discretionary order, my lord, without any basis, my lord, it has. On the basis of, my lord, Supreme Court decision in the said regard. It is only, my lord, an appeal on principle wherein, my lord, discretion is exercised, my lord, by the trial court.
Yes.
Relevant portion, my lord, I would take. Page number 30 of the said 30, wherein, my lord, Supreme Court decision is referred to and, my lord, followed, my lord, by this honorable court. In Muhammad Mehtab Khan, my lords, get it, my lord? Page number 30 of the said. Yes. So and so, wherein the relevant portion reads as under: in a situation where the learned trial court, on consideration of the respective cases of the parties and the documents laid before it, was of the view that the entitlement of the plaintiffs to an order of interim mandatory injunction was in serious doubt, the appellate court could not have.
Does this help you? The order of the trial court was not to construct otherwise than in accordance with law.
Now, my lord,
in accordance with law, they'll construct.
Now, my lord, completely blanket order is given. My lord, your lordship may kindly see, he has started putting up the construction touching my existing building.
You go before the authorities.
That is, my lord, admittedly joint family ancestral property as per his own pleadings.
Yes. Petitioner is before this court seeking.
May I request at least some conditions, my lord, be put so that the interest of.
A suit in OS number 80 of 2020 had been filed by respondent number 1 herein seeking for partition and separate possession of the suit scaled property. In the said suit, the petitioner, who is defendant number 2, filed IN number 4 under order 39 rule 1 and 2 of the Code of Civil Procedure, seeking for injunction restraining the plaintiff from putting up any construction in one of the properties on the ground, firstly, that the said property is subject matter of the suit. Secondly, that the construction is being put up without any plan sanction,
permission,
and in violation of the building bylaws. The trial court, vide its order dated 20th February 2024, partly allowed the said application, restrained the plaintiff from putting up any construction contrary to the applicable law. Challenging the same, the plaintiff had filed MA number 2 of 24 before the senior civil judge and JMFC at Nipani, who wide order dated 7 January 2025, taking note of the affidavit of undertaking submitted by the plaintiff, set aside the order dated 22/2024 invoice number 80 of 2020 and permitted the plaintiff to go ahead with the construction, provided the plaintiff shall not be entitled to claim any equity in the event of defendant succeeding in the suit and the defendant being entitled to share in the suit property. Defendant would be entitled to the share in the suit property, including all the addition and construction made thereon. It is challenging the same. The petitioner is before this court. Sri Ramchandra Malli, learned counsel for the petitioner, once again reiterates that the construction which is being carried on by the plaintiff is without a plan sanction and contrary to the building bylaws. And as such, the plaintiff ought to have been restrained by the first appellate court from putting up construction instead of accepting an undertaking given by the plaintiff that he will not claim any equities. If at all there's any violation of the, if at all there's no plan sanction and or the construction is violation of the building bylaws, it is for the concerned authorities to take necessary action. As regards which Sri Ramchandra Malli submit that a complaint has been filed to the local
Gram
Panchayat. In the present matter, the plaintiff putting a construction on a joint family property, the construction being at the advanced stage, it is not that the plaintiff has no right in the property, but the rights of the parties are yet to be determined by a preliminary decree to be passed in OS number 80 of 2020. Since the plaintiff has categorically stated that the plaintiff will not claim any equities in the construction, and if the property were to be allotted to any other person other than the plaintiff, such person would be entitled to the constructed area. And the considered opinion that the plaintiff would be carrying on the construction at his sole risk, cost, and peril. And any person who is granted the share of the property where the construction has been put up by the plaintiff would inure to the benefit of such person without the cost of construction being taken into account at the time of drawing up of the final decree proceedings. In that view of the matter, I do not find any infirmity in the order passed by the first appellate court. The submission on that ground. The other submission made by Sri Ramchandra Malli, learned counsel for the petitioner, is that there is violation of the construction is without obtaining a plan sanction and in violation of the building bylaws. The trial court originally injuncted the plaintiff from putting up any construction otherwise than in accordance with law. The said order of the trial court was not a blanket order of injunction, and it is in that view of the matter that the first appellate court, taking into account the undertaking given by the plaintiff, has permitted the construction subject to the plaintiff not claiming any equity. If at all there is any violation of, if at all the construction is without obtaining any plan sanction and or in violation of the building bylaws, without leaving the setbacks and or compliance of any other facet of the building bylaws, it is for the panchayat to take necessary action on the same in terms of the complaint submitted by the petitioner. That would not come within the purview of either OS number 80 of 2020 or MA number 2 of 2024, let alone before this court, reserving liberty to the petitioner to once again approach the Gram Panchayat for necessary action and directing the Gram Panchayat to act on the said complaint. The petition stands disposed.
Yes, great.
Please.
Two.
Application does not survive.
2. Anandar Kulli.
Please. For the petitioners.
Yes.
The pertainings to my lords, no confidence against Adhyaksha and Upadhyaksha, my lords. Where, my lords, I takes my lord's attention, page 29.
29.
Yes. This is the first round of litigations.
ಫಸ್ಟ್
Yes.
ಇನ್ನ ಬರ್ತೀರಾ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
No, no, no. I have to bring my lord's attention. This is my lord's challenge before this honorable court in WP 100258 of 25, where my lordship was allowed the writ petitions. Where my lords, thereafter my lords, page 31 my lords.
Yes.
On 23/1/2025, the the assistant commissioner had served my lords form number 2, where my lords I had made an application, page 32 my lords. I had made an application that my lords requesting the assistant commissioner to provide my lords the list of the members who had moved the no confidence.
Copy of form 1.
Form number 1. Where they had issued an endorsement stating that my lords
ಯಾವುದೇ ಅರ್ಜಿ ಸ್ವೀಕೃತಿ ಆಗಿರುವುದಿಲ್ಲ ಅಂತ
ಯಾವುದೇ ಅರ್ಜಿ ಸ್ವೀಕೃತ ಆಗಿರುವುದಿಲ್ಲ ಅಂತ ತಿಳಿಸಿದರು.
issued by the assistant commissioner.
Yes, ma'am.
Why there was a transfer of the assistant commissioner?
Please.
There was a transfer of the assistant commissioner or the same assistant commissioner?
Same assistant commissioner. ಬೇರೆ ಅಭಿಲೇಖಕರು ಆಗಲಿ ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳು ಆಗಲಿ ಅಲ್ಲ, ಬೇರೆ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ಸಿಗ್ನೇಚರ್ ಬೇರೆ
ಇದ್ದಾರೆ. But he is my lords, the office of my lords.
ಈ ಸಿಗ್ನೇಚರ್ annexure G signature ಬೇರೆ ಇದೆ.
Yes, but the authority issued my lords the assistant commissioner. Authority is issued my lords the assistant commissioner.
ನೀವು ಅರ್ಥ ಮಾಡಿ ಅವ್ರಿಗೆ ಅರ್ಥ ಆಯ್ತೇನು ಅಂತ. What is this endorsement must culture?
Allah, if he has completed, I will make submission.
ಹೇಳಿ.
Yes. Annexure G, my lords. So my lords, on 24 my lords, the notice of my lords form number 2 has been served at about 11:30 a.m. early morning on the members of the Gram Panchayat, including the Adhyaksha, my lords. To that effect, my lords, I had been produced the photographs.
Yes.
Where, my lords, there is no more an application by the members of the Gram Panchayat before the assistant commissioner. So the suo motu cannot have a jurisdictions by the assistant commissioners to issue a form number 2. First submissions, my lords. Second submissions, my lords, is on 22/2022, my lords, on 14/2/2020, where the earlier, my lords, the date has been fixed. And my lords, this honorable court has already been quashed the proceedings.
Where is the order of this court?
That was a common order which was passed.
That is not been released, my lords. Please, no, 100258, my lords.
ಎಲ್ಲ ರಿಲೀಸ್ ಆಗಿದೆಯಪ್ಪ, ನಿನ್ನೆದು ಮಾತ್ರ ರಿಲೀಸ್ ಆಗಿದೆ.
ಅಲ್ಲ, ನಾವು ಮೊನ್ನೆವರೆಗೆ ನೋಡಿದೆ. ಅಲ್ಲ, we have been verified.
Pass the order or some other bench?
No, in detail, lords. Yes, my lordship has passed.
ಯಾವತ್ತು?
On 20th, my lords. On 20th 1/2025.
Okay. Yes, ಹೇಳಿ.
There are certain
205.
258. Where, my lords, that, my lords, on the form number 2, where, my lords, an issue dated, my lords, 23/1/2025 is not in compliance of, my lords, rule 3 clause 1. Even, my lords, they say that, my lords, 31, page 31. ವಿಷಯ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯ ಬಗ್ಗೆ
ರೆಕಾರ್ಡ್ಸ್ ತಂದಿದ್ದೀರಾ?
To second part, my lords, after, my lords, the revealing if the form number 7 is form number 1 has been submitted before the court, then, my lords, I will argue, my lords, second part is concerned. Where, my lord? No, because no, nothing as such, my lords. That
if it is being submitted, you have no other argument.
But no, that is not. That is the, my lords, the core. On 23/1/2025,
either accept that there is a form 1 submitted or not submitted.
No, if, my lords, or if the endorsement is came to be, my lords, on 28/1/2025, which has been produced at annexure G, stating that, my lords, they have not been submitted the form number 1. If, my lords, the authority says that this endorsement is genuineness 1, They have not been submitted as such. Then, my lords, automatically the issuance of form number 2, my lords, automatically
But
goes.
if it is found there and the endorsement is wrong,
If the then, my lord, it is left to the discretionary of the court, my lords, that to the person who has been issued this, my lords, an endorsement, where, my lord, I should not be suffered. Because, my lords, as on today, my lords, this endorsement issued by the annexure G, it is a,
this is issued by Abhilekha Palakaru.
yes, my lords. He is a, my lords, was a PRO, public information officer, my lords, had been issued, where, my lord, after verifying, my lords, the records from the assistant commissioner, it is a letterhead, my lords, issued.
Assistant commissioner ಮೇಲೆ enquiry ಆಯ್ತು, PDO ಮೇಲೆ ಆಯ್ತು, ಕಾಪಿಸ್ಟ್ ಮೇಲೆ ಆಯ್ತು, ಆಮೇಲೆ ಏನದು ಇನ್ನೊಬ್ರು ಯಾರು ಆಫೀಸರ್ ಅವ್ರದ್ದಾಯ್ತು, ಇದು ಇವರೊಬ್ರು ಉಳಿದಿದ್ರು.
ಅಲ್ಲ, ಇದು ರೆಕಾರ್ಡ್ ಕೀಪರ್. The endorsement which has been issued is by the record keeper of the assistant commissioner office.
ಅಷ್ಟೇನಾ? ಕೊಡಿ ರೆಕಾರ್ಡ್. ಇನ್ನೇನಿದೆಯಪ್ಪ?
Let them produce, my lords. If they have
ಏನಿದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮುಗಿಸಿ ಒಂದು.
Yes, absolutely.
If you have any other argument, finish.
Yes, my lords. Clause, my lords, 3(1).
What do you notice of motion?
Panchayat.
Yes.
May I read, my lords?
Yes.
Clause 1. A notice of intention to make a motion under the proviso of 49 shall be in the form number 1, signed by less than the specified under subsection 49 clause 1, the total number of the members together, with a copy of the proposed motion shall be delivered in person by any 2% of the members signing in the notice to the assistant commissioner as such.
Yes.
The assistant commissioner shall thereupon convey the meeting for the considerations of the said motion of the office of the Gram Panchayat on the day of the appointed by whom shall be delivered within the 30 days from the day on which the notice under sub-rule 1 be delivered to him. He shall be give the members of the notice not less than 15 clear days notice. I have no protection under this proviso. Next, provided that where a holding of a meeting is stayed by an order of a court, the assistant commissioner shall adjourn the said meeting and shall hold the adjourned meeting on the day not later than 30 days from the day on which he receives the intimation about the vacating stay, after giving the members of a notice not less than 15 clear days notice as such of the meeting. Earlier date was fixed on 22/1/2024. That has already been quashed by this court.
Was it stayed?
No.
Was it stayed?
Allowing the writ petitions, my lords, is more than the stay.
It never was stayed. It was allowed.
It was allowed.
So ಇದು stay ಮಾತ್ರ. So because stay ಅಂದ್ರೆ ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ ಜನಕ್ಕೆ, ಆಮೇಲೆ ತಿಳಿಸಬೇಕು ಅಂತ.
Yes, ma'am. Absolutely.
That was never stayed. It was directly allowed and matter closed.
Yes, ma'am.
So this will not apply, this provision.
No. Next, the questions comes is intimation is such.
15 days notice.
15 days. If assuming for a moment that, my lords, on 22/1/2025, the entire, my lords, the proceedings is been vitiated. On the same day, my lords, I denied, my lords, there is no application of form number 1 by the members as such. Even assuming for a moment that, as my lordships expressed this, even assuming for a moment there is the no confidence form number 1 as such. On 22/1/2025, my lords, on the same day they can't move.
On the same day, who cannot move?
Members.
Under which provision?
On the provision of intimation as such. Until there is an intimation.
Mr. Kolli, that is only if there is a stay and the stay is vacated. Here there was no stay. That earlier notice was quashed.
Yes, ma'am.
Reserving liberty to the
Members.
Yes, ma'am.
members to move a fresh move.
Yes, ma'am.
It is up to them to move the next minute or next hour or next year.
Yes.
They moved it on the same day.
Yes, ma'am. But when my application
time limits under that notice,
yes,
under that requisition under form 1 starts immediately. AC ಅದೇ ದಿನ ಹೋಯ್ತು, ಅವರು ಗೊತ್ತು ಇದೆಲ್ಲ ಕ್ವಾಶ್ ಆಗತ್ತೆ ಅಂತ ರೆಡಿ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ರು, ಹಂಗೆ ಹೋದ್ರು AC ಆಫೀಸ್ಗೆ ಕೊಟ್ರು.
when I bona fidely made an application on 24/1/25,
That we'll consider.
Yes,
But this proviso will not apply.
absolutely. Yes, I agree.
We'll deal with it,
Yes,
but it won't apply.
the second defense that my lords are set up is in the form number 1, form number 2, as my lordship would take my lords page 31.
31.
Page 31.
Yes.
ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಅಧ್ಯಕ್ಷರ ವಿರುದ್ಧ ಅವಿಶ್ವಾಸ ನಿರ್ಣಯ ಬಗ್ಗೆ I my lord justice, whether that the reference is in proviso of in consonance with the law, as lordship my lords held in the earlier writ petitions. Kindly see my lords, come to my lords form number 1 and form number 2.
Yes.
In the my lords, next my lords, form number 2. Form number 2, see rule 3 clause 2 notice subject. My lords put it. Get subject, no confidence of motion against Adhyaksha or Upadhyaksha, so and so, so and so, Panchayat dash regarding. Where my lords, after the Gram Panchayat, it is specifically to be mentioned the date of submission of form number 1 by the members. No, no. It is a form number that too. Yes. Where I then I
to consider the no confidence motion against the Adhyaksha or Upadhyaksha of blank Gram Panchayat.
Yes.
Will be held on blank.
Yes.
Date ಮಾತ್ರ fill ಮಾಡಬೇಕು.
Yes.
ಯಾವ ಗ್ರಾಮ ಪಂಚಾಯತ್ fill ಮಾಡಬೇಕು.
Fill ಮಾಡಬೇಕು. Date.
Week the day blank of so and so at blank in the office of the said Gram Panchayat.
Yes, that has been date has been come to my lords in clause 3 clause 2. Clause 3 clause 2. Yes. May I read my lords again clause 3 clause 2.
Yes.
The assistant commissioner thereupon convey the meeting for the consideration of the said motion at the office of the Gram Panchayat on the date appointed by him, which shall not be later than 30 days from the day on which the notice under sub rule, from the date on which date. Here in the subject, the assistant commissioner is bound to mention the date submitted by the members of the Gram Panchayat in form number 1. Form number 1. Here, where my lords, the date is not coming not forthcoming
in form 2.
In form number 2, it is presumed to be that on 23/1/2025, the notice has been submitted on 23/1/2025. On 23/1/2025, as per the annexure G, my lords, there is no the form number 1 submitted by the Panchayati members. If it is taken, the 22/1/2022 was submitted as the form number 1, then my lords, it has to go, since not mentioning the date as in the standard format. Secondly, my lords, if form number 1 is submitted on 23/1/2022-25, then annexure G holds good.
Annexure G is
Annexure G, my lords, where submitted that my lords on 23/1/2025, ಯಾವುದೇ ಅರ್ಜಿ ಸ್ವೀಕರಿಸಲಾಗಿರುವುದಿಲ್ಲ.
22/1 ಬಗ್ಗೆ ಹೇಳಿಲ್ಲ, 21/1 ಬಗ್ಗೆ ಹೇಳಿದ, ಬರೀ 23/1 ಬಗ್ಗೆ ಹೇಳಿದ್ದಾರೆ.
On 21 turn they can't do much, since it is already the process is going on.
What is the submission, Mr. Kolli?
Yes, my lords.
If the requisite, when was that other petition
20th.
dismissed?
20th.
Allowed
20th.
So upload ಆಗಿದೆ.
ಇಲ್ಲ, ನಿನ್ನೆ ನೋಡಿದೆ.
ಆಗಿರಬೇಕು.
ರಿಲೀಸ್ ಆಗಿಲ್ಲ, ಪೆಂಡಿಂಗ್ ಫಾರ್ ರಿಲೀಸ್ ಅಂತಿದೆ.
ಆಗಿದೆ ಅಂತ. Anyway, that is not material.
Yes.
So this order was passed on 21/2025.
Yes.
So they could submit the requisition on 20th itself or any other day.
Any other day, my lords. Any other day. ಇನ್ನ
ಕೊಡದೇನೂ ಇರಬಹುದು.
Yes.
It is their choice.
Yes.
Now we'll have to only see when was it submitted.
Yes.
20th ಕೊಟ್ಟಿದ್ರೇನು ಆಯ್ತು. ಇಲ್ಲಿ ನಿಮ್ಮ ಯಾವ ಲೇಖಕರು ಇವರು?
Annexure G.
Annexure G, my lords.
ಲೇಖಕರು ಓನ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು
23ನೇ ತಾರೀಕಿಂದ ಅಷ್ಟೇ
ಮಾತ್ರ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿರೋದು ಅಷ್ಟೇ.
Yes.
ಯಾವುದೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಲ್ಲ, ಮುಂದೆ ಹೇಳ್ತಾರೆ.
ಬಹಳ ಹುಷಾರಾಗಿದ್ದಾರೆ ಅವರು.
ಅಲ್ಲಲ್ಲ, ಮುಂದೆ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಎಲ್ಲ ಯಾವುದೇ ಅರ್ಜಿ ಸ್ವೀಕರಿಸವಾಗಿರುವುದಿಲ್ಲ. So he is
qualified by the date.
Well, when it is under the democratic, my lords, setup, he is bound to give, my lords, the informations which has been submitted.
Very well drafted and whoever has drafted it.
And secondly, my lords, that's where, my lords, when the assistant commissioner is, my lords, not followed, my lords, in the standard format, the rule, form number 2 as such, not mentioning the date as such, where, my lords, it has to be done in a particular manner. Honorable Supreme Court, my lords, is clearly where, my lords, in another matter, my lords, lords, Honorable Justice S. Krishna Kumar is also been referred. But anyhow, my lords, I directly take my lords of attentions. Para 15, my lords. The ratio involved in the present case. The the 3 judge benches of this honorable court. Yes, my lords. Where judgment reported in so and so and so. Next para, my lords. In the said principle, it has been followed. This court of Chandru Puri Manvi so and so, principal secretary, Andhra Pradesh, where it is held, wherein the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner, following the provisions law without deviating any of the prescribed procedures, so and so, so and so. Similarly, this court in municipal corporations in in Greater Mumbai, MJ and Allahabad, so and so others, the bank has been followed the said principle since the advertisement contemplated the manner of the application forms and also the attempting the answer sheets. It has to be done in a manner so prescribed. Therefore, the reasoning given by the division bench of this honorable court on the account of lapse of time, what bit the petitioners might have attempted to the answer sheet is in different language is not been justified, as the use of the different language itself is dissented to the petitioners from any indulgence in the power of the judicial. Since the writ petition is used in the different language for filing of the applications of OMR, so the candidate is wrongly rejected. Therefore, the order sheet of the High Court cannot be sustained in the law. The same has to be set aside. Writ petition is dismissed, so and so. Where form number 2 prescribes
date to be mentioned, not
date to be mentioned.
Anything
Date
else?
to be mentioned. And my lords, where and my lords, along with form number 1, the form number 1 is to be compulsorily accompanied. Yes, compulsorily accompanied, because the candidates has to know against whom the members has been moved under the democratic system. So that is where section 3 clause 1 has to be read along with section 49. So once again I will trouble my lords to section 49.
Yes.
Every Adhyaksha, may I read, my lords? Every Adhyaksha or Upadhyaksha of a Gram Panchayat shall forthwith deemed to have been vacated his office if the resolution expressing want of confidence in him is passed by the majority not less than 2/3 of the total number of the members of the Gram Panchayat at the meeting specially convened for the purpose in accordance with the procedure contemplated as may be prescribed. Provided that no such resolution shall be moved unless a notice of the resolution is signed by not less than 1/2 of the total number of the members and at least 10 days notice has been given to the intention to move the resolution. Provided that no resolution expressing want of confidence against an Adhyaksha or the Upadhyaksha shall be moved within the first 15 months from the date. Provided that where a resolution expressing want of confidence in the Adhyaksha or the Upadhyaksha has been considered and negatived by the Gram Panchayat, the resolution in respect of Adhyaksha and Upadhyaksha shall not be forth moved within the 6 months from the date of the Panchayat. Where 3(1) again, a written notice of intention to make the motion of the provision of 49. So form number 1 must be accompanied with the form number 2.
Yes.
It has to be moved simultaneously, my lords. Assistant Commissioner simultaneously means along with the form number 2. It is both, my lords, both are not independent.
Form number 2 jote, form 1 has to be enclosed.
Enclosed.
That's all.
That is, my lords. And secondly, my lords, procedure contemplated, my lords, in the where the date of mentioning submitting the form number 1 is a mandatory provision to be mentioned by the assistant commissioner while giving the form number 2.
Yes.
So, my lords, there are some irregular, my lords, in my lords conducting the proceedings by the assistant commissioner as such, and my lords, where my lords annexure G clearly reflects that, my lord.
Reputation better.
Yes, I request this honorable court. Yes.
Or may I pass on the original records? Or that is the registry. Document number 1 is the registry which has been maintained, wherein for having received the motion of no confidence, that is on 22nd. I have just marked it.
Yes.
So, my lord, on 22nd, a motion of no confidence has been moved by the members to the assistant commissioner, which has been received as per the inward register. Next, my lord, notice having been served to document number 2 and 3 that has been received by the present petitioner Adhyaksha.
Where is the enclosure to it?
My lord,
Is the
insofar
form
as
number 1 enclosed?
yes, insofar as enclosure is concerned, my lord, that has been already held by the full bench of this court that proposed motion should not be accompanied. It is not mandatory in the Lakshmawa case.
The notice.
Notice.
My lord, thereafter, last document.
Motion need not be enclosed.
Huh.
Requisition notice has to be
My lord, the notice which has been served to the petitioner, is photographs are produced. Next photograph ಇದೆ ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಅವ್ರಿಗೆ ತಗೊಂಡಿದ್ದು
That is form number 2. That
ಅವರೇ
is,
ಅಧ್ಯಕ್ಷರು
that is form number 2, my dear. That is.
ಅದೇ
Form 2 ಆಯ್ತು.
ಎಸ್ my lord.
Form 1 serve
My lord, form number 1, that is the last document number 4, that is submitted to the assistant commissioner, that is on 22nd.
Has that been served on the petitioner?
No, that
and
is,
all members of the Gram Panchayat.
my lord, it is signed by all the members of the Gram Panchayat and it is submitted to the assistant commissioner.
Has it been served on the petitioner?
My lord, that is, it is not served to the Adhyaksha, that is the petitioner. It is,
Served.
no, it is straight away submitted to the assistant commissioner.
It is submitted to the assistant commissioner.
Yes, my lord.
When the assistant commissioner issues the notice in form 2,
Yes, my lord.
copy of form 1 has to be accompanied, has to accompany form 2.
For that reason, my lord, the Lakshmana judgment, it says that proposed notion of no confidence accompanying that is not mandatory.
ಅದು proposed motion of
Proposed
ನೋಡಿ,
motion.
para 28 and
Yes, my lord. Para 9, 10 and 11 of that judgment.
para 11 ನೋಡಿ.
Please. Page number 10, my lord, of the compilation. On para 10, on page 14, my lord. On perusal of the
Para
records,
10
especially.
ನೋಡಿ.
Please, 10, para 10. On perusal of the records, especially the written notice, we find that there is substantial compliance of Rule 3(1) of the rules. In such cases, mere attracting the copy of proposed motion would be a duplicate of the work, and that by itself cannot be a ground to set on the democratic exercise of the members in functioning of these local governments. When the notice of majority members making it clear their intention, mere non-enclosing the proposal would be only an irregularity, and in overview does not cause any prejudice to the other side. The learned single judge in the case of Mallamma has merely relied upon the language of Rule 3(1) and held that if the notice does not accompany separately, the proposed motion of no confidence is bad in law. We do not agree with this proposition. In our view, non-compliance has to be seen in the background as to whether the same has caused any prejudice to the person aggrieved. So, my lord,
In our
enclosing
view,
of
since the notice also incorporates the proposal of no
yes,
substantive compliance.
yes, my lord. So, my lord, enclosing of form number 7 along with the form number 2 does not arise. This fact of the matter has been already dealt by the lordships in WP number 10364 of 2025. All the questions, whatever the petitioner that has been raised now today in this case, has been already considered.
ಅಲ್ಲ ಅದರಲ್ಲಿ proposed motion.
ಅಲ್ಲ ಅದು ಬಂತು And
Acquisition notice.
yes, and also insofar as form number 1 also, that has been also dealt. With regarding to non-mentioning of form number 1 in
ಅದು
the
dealt
motion,
ಆಯ್ತು.
that has been also
ಇದು
dealt.
ಇನ್ನೊಂದು ಹೊಸ
ಇವ್ರು form number 2
ಇದನ್ನು ಡೀಲ್
will-
ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅದಕ್ಕೆ and insofar as annexure G is concerned, my lord, their request was any such motion of no confidence was moved on 23rd. Request letter is at, my lord, annexure page 32, annexure F. They request ದಿನಾಂಕ 23/1/25ರಂದು so and so ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅವಿಶ್ವಾಸ ಗೊತ್ತಿಲ್ಲ ನೀಡಿದ ದೃಢಕತ ಪ್ರತಿ ಪೂರೈಸುವ ಕೊರತು. So on 23 there is no such.
No. They could have given, my lords, they could have given.
Well, he sought on 20
Specific question, they have answered a
specific answer.
No, my lords.
You should have asked, is there a no confidence motion received?
No, yes, sir. If, my lords, if
ಅದಕ್ಕೆ cleverly drafted and
no, if that could be the case, my lords, they could have been mentioned the date of, my lords, submitting the form number 1.
Also mentioned.
Allah, he would have simply said that
State
any
is more intelligent than a common man.
Both of
Allah,
you sit down now.
the state is more intelligent. Where, my lords, kindly see, my lords, the form number 2.
ಆಯ್ತು Mr. ಕೊಳ್ಳಿ, we will deal with all your submissions. ಕೂತ್ಕೊಳ್ಳಿ. Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the notice dated 23/1/2025 issued by
respondent number 1.
First respondent assistant commissioner calling for a meeting to be held on 14/2/2025 to consider a motion of no confidence against the petitioner, who is the Adhyaksha stroke president of the Ire Singanagutti Gram Panchayat. The submission of Shri Anand Kolli, learned counsel for the petitioner, is that the notice issued by the assistant commissioner in form 2 is not proper. He is not in accordance with sub rule 1 of rule 3 of notice of so and so 1994. The said notice does not mention the date on which the requisition notice had been submitted by the members of the Gram Panchayat. He submits that the requisition notice has not been enclosed along with form 3, form number 2, and therefore the same is in violation with the mandatory requirement of sub rule 1 of rule 3 of so and so rules. His submission is also that the requisite number of members have not signed the requisition notice. As such, the same does not qualify the requirement of subsection 1 of section 49. The first proviso to subsection 1 of section 49. He submits that once earlier, a requisition notice having been moved by the members of the Panchayat, the same having been challenged before this court in WP number 100258 of 2025. And this court having quashed the said requisition notice and the notice issued by the assistant commissioner, wide order dated 20th January 2025. In terms of proviso to sub rule 2 of rule 3, no notice could be moved. No notice could be issued within 30 days of the said order. The order passed by this court being dated 21/2025, no such notice could be issued by the assistant commissioner until 22/2025. The present notice having been issued on 23/1/2025 is contrary to proviso to sub rule 2 of rule 3. His submission is also that on an application being made to the information officer of the panchayat, the said information officer on 28/1/25 has categorically indicated that there is no requisition notice submitted on 23/1/2025. As such, he submits that there is no requisition given by the members of the Gram Panchayat for the Assistant Commissioner to act on in terms of sub-rule 1 of rule 3 and issue a notice in form number 2.
Information given by the Assistant Commissioner Office, not by the
Assistant Commissioner.
This is the information officer of the
Assistant Commissioner Office.
Assistant Commissioner.
Yes.
ENA.
Panchayat.
Panchayat, Assistant Commissioner's Office. Astella? On all the above grounds, he submits that the notice issued by the Assistant Commissioner at Annexure E is required to be quashed by allowing the above petition. Apart therefrom, a request has been made for compensation to be also awarded to the petitioner for having violated the mandatory requirement of sub-rule 1 of rule 3. Shri V.S. Kalsurmat, learned AGA, having produced the original records, submits that the requisition notice was received by the Assistant Commissioner's Office on 22/1/2025 and an entry thereof has been made in the inward register, copy of which has been produced, and such entry is found mentioned at item
7032.
7032.
Please.
He submits that in furtherance thereof, notice had been issued on 23/1/2025, providing 15 days clear notice to the petitioner of the proposed no confidence motion to be considered on 14/2/2025 at the meeting to be held at 12 p.m. in the office of the Gram Panchayat. Insofar as the endorsement issued by the Public Information Officer, he submits firstly that the application filed by the petitioner was with a specific request calling upon the information officer to indicate if a requisition notice had been received on 23/1/2025, and it is in that background that the information has been provided indicating that no requisition notice was received on 23/1/2025. If the question had been otherwise, it could have been answered that a requisition notice had been received on 22/1/2025. Thus, he submits that the petitioner cannot place any reliance on the said reply of the Public Information Officer. A requisition notice having been received by the Assistant Commissioner on 22/1/2025, the Assistant Commissioner has issued the notice fixing the date of the meeting as 14/2/2025, which provides 15 days clear notice. The same being in accordance with law, the claims made by the petitioner not being sustainable, the petition is required to be dismissed. Heard so-and-so perused papers. The points that would arise for consideration are: 1, whether the Assistant Commissioner can issue a notice in terms of Form 1 without Form 2 without a requisition notice having been received in terms of Form 1. 2, whether the requisition notice in terms of Form 1 is required to accompany the notice fixing the meeting in terms of Form 2. Whether an earlier challenge being made to whether a challenge has been made to earlier notice issued by the Assistant Commissioner, the Assistant Commissioner cannot issue a notice in terms of Form 2 fixing the date of meeting until 30 days thereafter.
Whether, my lords, date of submitting the form number 1 is mandatory.
Whether the date
in form
of receipt of form number 1 is mandatorily required to be mentioned in form number 2. ಅಷ್ಟೇನಾ? So 4 items close ಮಾಡಬೇಕು ಅಂತ. What order? The submission of Shri Anand Kohli, learned counsel for the petitioner, is that the requisition in form number 1 has never been received by the Assistant Commissioner's office. Therefore, the notice under form 2 could not have been issued. In this regard, he relies upon the endorsement issued by the information officer of the Assistant Commissioner's office dated 28/1/2025. This reply of the public information officer is in pursuance of a requisition made by the petitioner on 24/1/2025. A reading of the said requisition for information indicates that the request has been made, specifically indicating as to whether any requisition notice for moving a no confidence motion has been received on 23/1/2025. And it is in that background that the information officer has replied stating that no such requisition has been received on 23/1/2025. Thus, both the query raised by the petitioner and the answer given by the information officer is with respect to a requisition notice having been received on 23/1/2025. There is no particular request made in general as regards inquiring inquiring as to whether any requisition notice has been received, but a specific request has been made inquiring as to whether requisition notice has been received on 23/1/2025. If at all the petitioner had sought for a general query, probably the answer could have been different. Based on the said endorsement issued by the information officer, the petitioner cannot contend that there is no requisition notice which has been received by the Assistant Commissioner. More so, on a perusal of the original records which have been produced, which would indicate that in the inward register, there is an entry made at item number 7032 of the requisition notice having been received on 22/1/2025. Thus, the endorsement of the public information officer would not help the petitioner in any manner. Requisition notice having been received on 22/1/2025, it cannot be said that there is no requisition notice received by the Assistant Commissioner. Hence, I answer point number 1 by holding that though it is required for a requisition notice in terms of form number 1 being received by the Assistant Commissioner, in the present matter, such requisition notice having been received, the Assistant Commissioner has taken necessary action pursuant thereto. The answer to point number 2. The submission of Shri Anand Kohli, learned counsel appearing for the petitioner, is that in terms of proviso to sub-rule 2 of rule 3, the Assistant Commissioner could not issue any notice until 30 days of the orders passed by this court dated 21/2025 in WP number 100258 of 2025. The proviso to sub-rule 2 of rule 3 is reproduced hereunder for easy reference. A perusal of the said proviso would indicate that if the holding of a meeting is stayed by an order of the court, the Assistant Commissioner would have to adjourn the meeting fixed and hold the adjourned meeting on a date not later than 30 days from the date on which he receives intimation about the vacation of stay, after giving the members a notice of not less than 15 clear days of such adjourned meeting. In the present case, there is no stay of the notice issued by the Assistant Commissioner in WP number 100258 of 2025. The said writ petition came to be disposed on the date it was taken up for admission. The requirement of the purport and meaning of the proviso is that when a stay order has been passed and the matter adjourned, it is only after the Assistant Commissioner comes to know of the vacating of the stay that a notice fixing the meeting not later than 30 days from the date on which he receives the information is to be fixed. However, it is qualified by issuing a notice of not less than 15 clear days of such adjourned meeting. That would imply that from the date on which the Assistant Commissioner comes to know of the vacating of the stay, within 30 days, the meeting has to be fixed. That does not mean that he has to wait for 30 days, but there's a mandatory requirement and obligation cast on the Assistant Commissioner to hold the meeting within 30 days. But while doing so, the Assistant Commissioner is required to issue a notice of not less than 15 days to the Adhyaksha, Upadhyaksha, and the other Gram Panchayat members. Thus, even though there was no stay granted in WP number 100258 of 2025, the said writ petition having been disposed of on 21/2025, quashing the earlier requisition notice and quashing the requisition notice as also notice issued by the Assistant Commissioner, the earlier proceedings came to an end and the same could not be relied upon by any of the parties. Thus, the question of holding a meeting, holding an adjourned meeting would not at all arise, since the earlier requisition and the notice issued by the Assistant Commissioner could not be considered in the meeting to be so fixed. The earlier requisition and notice issued by the Assistant Commissioner having come to an end with the passing of the order on 21/2025 in WP number 100258 of 2025, any other requisition issued is a new requisition which would have to be dealt with in terms of sub rule 1 of rule 3, read with section 49 of so and so act. In that view of the matter, I am of the considered opinion that in the present matter, the proviso to sub rule 2 of rule 3 would not be applicable. The requisition having been submitted by the requisitionist Gram Panchayat members on 22/1/2025, in terms of the liberty which had been reserved, while order dated 21/25 in WP 100258 of 2025, it was for the Assistant Commissioner to issue a notice of not less than 15 days in terms of proviso.
Second proviso 49. Second. Allah, first proviso.
First proviso.
Yes.
To subsection 1 of section 49, which has been done in the present matter. That's answer point number 2 by holding so and so. This answer to point number 3. The submission of Sri Anand Palli Learned Counsel for the petitioner is that the requisition in terms of form number 1 is required to accompany the notice issued by the Assistant Commissioner in form number 2. This issue is no longer res integra. The aspect has been considered in detail by the division bench of this court in ILR 2007 Karnataka 1028. The relevant paras being para 4, 10, 4, 6, 10, 11 and 12 are reproduced hereunder for easy reference. The perusal of para 4 of the aforesaid judgment would indicate that what fell for consideration of the division bench of this court is whether the notice of no confidence motion should accompany a copy
of proposed motion at para 4 last 2 lines.
Para 4 Allah, sorry.
Forman and should accompany a copy of para 4 ದಲ್ಲಿ last 2 lines ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಕೊಟ್ಟು ತಡಿ ಇವಾಗ ಕೊಡ್ತೇನೆ.
That whether the proposed motion in terms of a requisition issued under Form 1 should accompany the notice issued by the Assistant Commissioner. Bracket, needless to say, in terms of Form 2, bracket close. The division bench has categorically come to a conclusion at para 10 extracted above that when notice of majority members makes it clear their intention, mere non-enclosing the proposal, bracket, requisition notice in terms of Form 1, bracket goes, non-enclosing the proposal would be only an irregularity and does not cause any prejudice to the other side. The proposal, which is referred to in para 10 of the aforesaid order, is the requisition notice in Form 1, since that is the proposal submitted by the requisitionist, Gram Panchayat members, for moving a no confidence motion. At para 12 of the aforesaid order, the division bench having come to a conclusion that since the notice refers to the proposal of no confidence motion, there is substantive compliance of the requirement of sub-rule 1 of rule 3 of the rules. This said decision of the division bench would equally apply to the present facts. A notice having been issued by the Assistant Commissioner indicating that a proposal for no confidence would be considered in the meeting to be held on 14/2/2025. The proposal of no confidence being included in the said notice issued in form number 2 under sub-rule 2 of rule 3 would be in compliance with the requirement of law as held by the division bench in Lakshmava's case. Answer to point number 4. The last submission of Sri Anand Kohli, learned counsel for the petitioner, is that the notice issued in form number 2 should mention the date of the notice of the requisition notice. And in this regard, he refers to form number 2 appended to the rules. The said form number 2 is reproduced here under for easy reference. A perusal of the form number 2 indicates only that a no confidence motion indicates that the subject should contain a reference to the no confidence motion to be moved against the Adhyaksha or Upadhyaksha of a particular Gram Panchayat, and that a meeting would be held to consider in the body of the said notice. It is stated that it is to be stated that a meeting to consider the no confidence motion against the Adhyaksha or Upadhyaksha of the said Gram Panchayat will be held on a particular date at a particular time in the office of the Gram Panchayat. Nowhere in the said form 2 there is a requirement to mention the date on which the requisition notice has been received by the Assistant Commissioner. The notice in form number 2 is only required to fix the date on which the meeting of the Gram Panchayat would be held, the time at which it would be held, and the said meeting to be held at the Gram Panchayat. Thus, having gone through the said form number 2, which has been reproduced here and above, it is clear that there is no requirement to mention the date on which the requisition notice has been received. In that view of the matter, this submission of Sri Anand Kohli, learned counsel for the petitioner, would also be liable to be rejected. I answer point number 4 by holding that the date of the requisition notice is not required to be mentioned in the notice issued by the Assistant Commissioner fixing the date for holding the no confidence motion. What order? In view of my answers to all the points above, no grounds being made out, the petition stands dismissed.
Obliged.
ನೆಕ್ಸ್ಟ್ ಇನ್ನೇನ್ ಗ್ರೌಂಡ್ ತಗೊಂಡ್ ಬರ್ತೀರಾ?
All issues has been settled.
ಗೊತ್ತಿಲ್ಲ. ಅದೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಸುನಿಲ್ ದೇಸಾಯಿ ಆಲ್ ಇಶ್ಯೂಸ್ ಸೆಟಲ್ಡ್ ಅಂತ ಹೋದ್ರು. ನೀವು ಇನ್ನ ತಗೊಂಡ್ ಬಂದ್ರಿ. ನೆಕ್ಸ್ಟ್ ಬಣ್ಕರ್ ಅಲ್ಲಿ ನಗ್ತಾ ಇದಾರೆ. ಇನ್ನೊಂದ್ ಎರಡು ಇಶ್ಯೂ ತಗೊಂಡ್ ಬರ್ತಾರೆ.
Only our duty is only to extract the juice whichever already.
Your duty is to do the best for your client.
Yes, yes, obviously.
Leave it to the court.
Yes.
You did your best.
3.
I request, my lords could don't mind, my lords. May I request for to release earliest as possible the order
ಇದೆಲ್ಲ ಟೈಪ್ ಮಾಡೋಕೆ give them time.
within.
ಟೈಪ್ ಆಗಿ ಬರುತ್ತೆ.
RM ಹಿರೇಮಠ್.
Lord, this is with regarding.
Earlier one release ಆಗಿದೆ.
Yes.
ನೋಡಿಲ್ಲ. ನೋಡ್ಕೊಳ್ಳಿ.
Lord, this is with regarding to requisition of the PDO. Yesterday I made a submission that there are 2 requisitions which has been enclosed in the writ petition, but only one requisition, but they have ಎರಡು ಹಾಕಿದಾರೆ ಅವರು ಅಷ್ಟೇ.
No, my lords, the thing is, as per Annexure B, my lords, when notice was issued to this petitioner, a requisition has been given along with it. But Annexure C is the certified copy of the same requisition that bears the endorsement of the PDO. So subsequent to issuance of notice, these changes have been done in the requisition.
You are for whom? The
Adhyaksha.
For the Adhyaksh, my lords.
Anyway, there is an endorsement, so you'll succeed on that.
It has to be allowed.
Please, my lords, but this shows that after issuance of notice, these changes are done. This is in contravention with what your lordships have held in the recent decision.
You are,
Sangan
by that submission, you'll go against yourself.
No, my lords, the requisition has to be quashed
Are
because.
you understanding your submission?
Please, my lords.
When the notice was submitted by the members,
Please.
it had no endorsement of the PDO.
Please.
Then writ petition has to be allowed.
Writ petition dismissed.
Dismissed. Yes, ma'am. Sorry. It has to be dismissed.
Please, my lords,
If only you are referring to 24, can your writ petition be allowed?
please, my lords, I'm referring to
23, your
20.
petition will go.
Please, my lords, I'm referring to 24.
Please. Don't complicate it.
Please.
100,205, my lord.
Before
Lordship's
this court
order.
seeking for the following relief. Same order as in 100,005.
205 of 25.
Date matra check ಮಾಡಿ annexure.
Please, both the matters.
3 and 4, 3.1.
Please.
Action to be taken against the PDO.
Please.
ನೀವು ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದು is no action.
ಇಲ್ಲ.
Which one is the one where you are directing?
Lord, not in 205. It is passed. No, not in 205.
Yesterday's matter, my lords,
ಇಲ್ಲ.
100316.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ.
Same assistant commissioner.
ಯಾವುದ್ರಲ್ಲಿ action? Otherwise they'll continue
And also in 100,364, Sunil Desai dismiss ಮಾಡದಲ್ಲೇನು there is a direction to how 364 of 2025.
where have we considered not this? Bari ಇದು ಸುನಿಲ್ ದೇಸಾಯಿ ಇದಲ್ಲ.
ಅಲ್ಲ, in yesterday one lordships 100,316 wherein my lord directed the
0316.
Both the
Court speed 100.
principal secretary 316.
Please.
Scan permission.
Pertains to principal bench, Bengaluru.
Everybody is here? We'll filed
The
by
contesting.
R5 to 13.
Yes, madam. He is the contesting
They are the
respondent.
contesting respondent.
Ah.
And the party, they have amicably settled the dispute. That writ petition needs to be allowed.
Decision to be allowed, ಹಂಗಾಗಲ್ಲ. We'll have to see.
Parties are already signed, my lord.
Seal number 57, my lord. 57. 2 weeks time we grant time for the respondent, my lord. I have to get instruction, my lord.
57.
Specific date may be given, my lord. 2 weeks.
Request of counsel for respond number 1 and 2 seeks and is granted 2 weeks time.
Yes. Lord. Date may be fixed, my lord. No.
Relist on 20th February.
Yes.
Lordship, serial number 50.
44. ಇಲ್ಲಿಂದ ಬರ್ತೀವಿ 44 ಏನು ಹೇಳಿ ಅದು ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ petitioner relist on 14th February.
Serial number 50, Lordship. Serial number 50, Lordship. Kindly have it on next week
ನೀವು ಯಾರಿಗೆ?
for petitioner, Lordship.
You inform the respondent?
Yes, we have informed other side also.
Special counsel for the petitioner released on 14th.
Serial number 59.
50?
9.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ರೆಸ್ಪಾಂಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Respondent. Yes.
ಅಲ್ಲಿ ನೋಡೇ ಬೇಡ.
serial number 5 in the first list, ಒಂದು ಸಣ್ಣ ಸಬ್ಮಿಷನ್ ಇದೆ ಅದರಲ್ಲಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಗೆ kindly issue emergent notice.
ಅಲ್ಲಿ ಮಾಡಿದಾರೆ.
There are some legal acts. I clarified the matter with the petitioner.
Respond number 4 ಗೆ deceased.
Deceased, he is having a legal head.
Application.
If he has legal heirs, you have to file application.
Application ಹಾಕಿ.
Issueless ಅಂತ ಅಷ್ಟೆಲ್ಲ ಆರ್ಡರ್ ಮಾಡಿಸಿದ್ರಿ.
ಇಲ್ಲ, earlier person has died interstate and yes, he is.
ಯಾರು?
Earlier one focal entry was made in this.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಗೆ ಹೇರ್ಸ್ ಇದಾರಾ ಇಲ್ವಾ?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 4 ಗೆ ಇದ್ದಾರೆ.
ಇದ್ದಾರೆ ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಯಾರಿಗೆ ಕೊಟ್ಟು?
Serial number 41. I am for the respondent. I have informed the petitioner counsel also informed. Next week any date.
Even at the request of counsel for respondent, released on 14th.
Serial number 37.
Yes.
Next week any date.
The request of counsel 2015.
I am ready, my lord.
Released on 7th. 2015 ಇಂದ CPC ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಮಿಸ್ಟರ್ ಶೆಟ್ಟಿ?
Only
Stay ಇದೆಯಾ?
Stay ಇದೆ. Only stamp duty question is.
Earlier granted 6.
Serial number 66, my lord. List number 2.
Yes,
Serial number 35, list number 2.
List number 2. Yes, madam.
Serial number 66, my lord. List number 2. I am for respondent number 5 and 6. I have to file objections, my lord.
2 ಎಲ್ಲ ಅಡ್ಜರ್ನ್ ಆಗಿದೆ.
Adjourn.
They'll give you the dates.
Okay. Court officer? List number 2 ಗೆ ಏನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ? 66. 66.
Court officer? Court officer?
List number 2.
11-2.
11-2. 66 serial number.
ಹೌದು. ಸರ್ ಹೇಳಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 8281 ಸಬ್ 1 ಅಂತ ಇದೆಯಲ್ಲ 107536 ಅದು ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ ಡೇಟ್ ಆಗಿದೆ.
ಲಿಸ್ಟ್ ನಂಬರ್
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗ್ದ ಕಂಟಿನ್ಯೂಸ್ ಆಗಿದೆ ಮತ್ತೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇನ್ಚಾರ್ಜ್ ಕೋರ್ಟ್ 6th ಕೋರ್ಟ್ ಆಫೀಸರ್ ಅದರಲ್ಲಿ 82 ಮತ್ತೆ 8.1 ಎರಡು ನಮ್ದೇನೆ. ಸೆನೆಗೌಡ ಕೆಜಿ.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ ನೀವು.
ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅಂದ್ರೆ ಕಂಟಿನ್ಯೂಸ್ ಸೀರಿಯಲ್ ನಂಬರ್.
ಸರ್ 62 ಅದು ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
62 ಗ
ಹೌದು.
52 ಬೇಕಾಗಿತ್ತು. 52
ಕೋರ್ಟ್ ಆಫೀಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಸರ್ ಹೇಳಿ ಸರ್.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆಯಾ ಬಿ ಗ್ರೂಪ್?
ಇಲ್ಲ, ಫಸ್ಟ್ ಬೆಂಗಳೂರು ಇದೆ, ಅದಾದ್ಮೇಲೆ.
ಹೌದಾ, ಆಯ್ತು.
ಏನ್ ಇಂಟಿಮೇಷನ್ ಇಲ್ಲಪ್ಪ. ಏನ್ ಮನುಷ್ಯ
lordship, grant is made, my lord. Earlier it was 2 acre, my lordship. Only grant is made in out of 2 acres, my lordship. 1 acre 20 guntas was granted, my lordship. Subsequently, for remaining 20 guntas, my lordship, at Annexure C at page number 22, he made one more application, my lord. But he was in possession, my lordship. That application is still pending, my lordship. Thereafterwards, my lordship, there was an intervention of the villagers with respect to this 20 guntas, my lord.
1 acre 20 guntas. How much do you want?
No, another 20 guntas, my lordship. I have made one more application.
In possession of the whole village and the whole
No,
village.
I'm in possession of that, madam. And
Possession
subsequently, I filed a suit for
It's not
injunction.
your land. You are in unauthorized possession.
Please.
You made an application, you're being given 1.2.
Please.
You can't be asking for everything.
No, my lordship. Subsequently, I filed a suit for injunction, my lordship. It is some villagers who are obstructing my possession, my lord.
Who are you to file injunction?
My lordship, injunction is granted in my favor, my lord.
Adu appeal like
Injunction is granted, my lordship. Subsequently, I have filed.
Government is not a party.
Government is
Land
not
is
a party in
government
that
land.
injunction. No,
Land is
government is
government
not interfering, my lordship. Government is not interfering. My lordship, I have given representation at Annexure E,
Interim release. Third AG accepts notice for
page number
respond
50, my lordship.
1 to 7. You have
Government,
not made
government.
the person who are interfering party to this.
But I have given representation to the deputy commissioner, my lordship.
You have not made them a party.
I have given representation to the who are disturbing my peaceful possession, my lordship.
Have you given the details?
Please, my lordship. In my representation, I have given the details.
Can't you make them party?
Before this court, I have not made the court. But my representation is not at all considered, my lord. At page number 51, my lordship, kindly, my lord. Page number 51,
them-
Annexure E, I made representation to the Assistant Commissioner, Deputy Commissioner of Karwar, my lord.
Mr. Counsel,
please.
You are trying to abuse the process of this court without making them party, getting an order, and ಅಲ್ಲಿ police ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು high court order ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು.
ಇಲ್ಲ, ಆ ಥರ ಅಲ್ಲ, my lord.
ಮತ್ತೆ ಅವ್ನು party ಮಾಡಿ ಇಲ್ಲಾರೆ dismiss.
Please, I'm permitted to make the party.
Counsel and AGA accepts notice for respondent 1 to 7. Counsel for the petitioner seeks for and is granted 2 days time to file necessary application to bring on record the persons against whom the petitioner wants action to be taken.
Please. May I seek a particular day, my lord?
Relist on
7th, my lord.
7th.
Please, much.
2, Vittal Tili.
The petitioner is the owner of a suit item number 634, 3 and 4. Lords filed a suit for partition and separate possession, Annexure A, page number 10. Suit came to be decreed. Final decree came to be allowed. My name came to be mutated. Since from last more than 1 year, my lords, I am requesting the police. My uncles and others are not allowing me to cultivate. Page number 23, my lords.
You own party madilla illi.
Lords, I am not saying, lords. Only, my lords, my request. Now the sugar cane is grown.
On party madde henge, Mr. Teli.
Lords, even if, again, I
The ones who are going to be affected.
let there be a
You want
direction.
an
only-
order behind their back.
So may I take for a moment, my lords, one for a moment. Sir. Page number 24.
And this is a interim order you are asking for protection of the petitioner to cultivate.
No, page number 24 for a moment. Page number 24. These are the endorsement issued. They say only LPT and they issue the endorsement me. 24, 20, page number 24, 25, 26. And 27, where my only son is serving at a defense. They have also requested them, my lords, page number 27.
Going on for 1 year, you make them a party, we'll issue them notice and then hear them. They are going to be affected. We are not passing orders against.
Only my grievance, I am not saying, let their
And AGA accepts notice for respond number 1 to 6. ಏನ್ ಮಾಡ್ಬೇಕು ಪಾರ್ಟಿ ಮಾಡ್ತೀರೋ ಇಲ್ವೋ?
party ಮಾಡ್ತೀನಿ ಇಲ್ಲ ಅಂತಲ್ಲ. Only one request.
Seeks for and is granted a week's time.
Lords, I request on Tuesday.
2 days time to file necessary application to bring the persons against whom a request for action is
here,
has been made to the police to take action on record. Released on 5th.
4th, my lords. Mayor.
4th.
3, Sunita P. Kalsu.
Yes.
Your lordships, the petitioner is an ex-serviceman. He has purchased the land. The sale deed is produced at Annexure B. Vide this Annexure B in the year 2005, 2013, even the